Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
The next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What for? You see? Because he's the guy.
Good afternoon. Good afternoon. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Oh, I just went to the wrong corner. I fat fingered the button there. It's one of those days.
If they didn't,
There we
I
go.
would lose my mind.
Welcome back, everyone. Welcome, Ashley. Ashley, welcome. First in chat, but no, this comment's the one I wanted to highlight. RA is late. Like a minute and a half. Barely a minute and a half late. That was about it. We're back. We're excited for starting the afternoon session.
I saw a chicken fight.
Saw a chicken fighting. Really colorful chicken. Never seen that before. Welcome.
Shame on you, sir.
Oh, I'm sorry. I was late, Icy Cat. I was definitely late. Ashley, first in chat, we're going to send it to you with internet ownership. You have won before, and you know what to do. Congratulations, my friend. Thank you for kicking off chat for everybody today by just blurting out whatever it was you blurted out before you said I was late. I forgot what it was. I'm just high. I don't know what it was. Welcome to those who are new. Welcome to those who are just joining us maybe for the first day. Love that you're here. We have a fun community here where we don't always agree with each other, but what we do try to do is be respectful to not just the people we're talking about, but the people we're talking to. So I'd ask you to join in on that if you can follow those same rules. Our mods work overtime trying to make sure, if there are a few people who don't understand how society works, that they get a loving correction. Please be nice to the mods. They're doing the best they can, and they're working for free. So please thank them by being polite in chat. That would make their day much easier. So thank you. We all still love each other at the end of the day. Yes, we can disagree, and we love having disagreements. I mean, especially ones where we can listen to each other and listen to why other people feel the way they do. That is great. Look at that. We've got 59 to 88 as far as subscribers. Thank you. We have quite a few new people here. Welcome. It looks like maybe here in the next couple of weeks we might hit that 60,000 number, which will be time for a party for sure. All right, I was able to have my doctor's appointment during the break. I missed nothing. Yay, Shannon, that is wonderful that it worked out that way. Miss Kitty, I can't type on my iPad. That is a dilemma. That is the dilemma. Nope. All right, we are still on lunch. We just have the wall to look at here, so we will do that. But oh my goodness, the thing I want to talk about just for a moment. Oh, that's not it. I keep forgetting. I need what I say need like I need it. I don't need it. I would like another ME, another switcher, so I can have multiple switcher sets. Does that make sense? Makes sense. So anyway, that way I could do layer upon layer. I need another screen is what it is. I need another screen. I was going to say, I wanted to talk about the objections being up to 86 already. 86 is a ton.
If they didn't, I would lose my mind.
We're losing our mind over the objections. It is just crazy. The spiciness today, we started at 38. So our first day of trial, we had 38 objections, which we thought was a lot. We've already doubled that plus, and we're only halfway through the day. It has been incredible. We are, believe it or not, we're very close to the end of the state's case. We get a half day today. We get one witness on Thursday, and the state will rest. So Do I need a bigger table yet? Pi Lee said the problem is if I get a bit bigger table, I just put more stuff on it. I've learned this from sad experience throughout my life. The more space I have to put junk, the more junk I will find to put on that space. And it's a balancing act. Small table keeps Mrs. R.A. happy because equals less junk. But I do need a new table eventually. Charlotte says, I love how kind everyone is here. I'm a new subscriber, just a few weeks in, so glad I found R.A. Charlotte, I'm glad you found us as well. Welcome to this amazing community. And it is the community, I think, that as you've recognized, is just so incredible. I found them as well, and they are just wonderful, wonderful people. Glad you're now part of it. Welcome. Let's see. Sink comes first. Bidet comes first, and some of you might say, why is he talking about a bidet? Long story. I fixed the lawnmower yesterday. It's been a month or so. Maybe it's been all summer. Okay, it's been like a year since the lawnmower is broken, but I fixed it yesterday in 1 hour. Completely took the carburetor off, replaced the carburetor, put it all back on, attached everything, and it worked. It fired up the first time. It was beautiful. I redid my bathroom upstairs, and I'm not a construction guy. And we did it, and we always joked that we were going with the best of the best. We were going to put in a bidet. It became a thing. We're going to put in a bidet. We just haven't done it yet. I didn't realize bidets cost what they do, and so the bathroom we thought we had allocated like $250 to do a little toilet repair, because the tank on the back leaked and it damaged some flooring. Turned into be about a $6,000 job. Yeah, that hurt. So the bidet is not quite in the budget yet. When it is in the budget, we will add it and upgrade the bathroom for that. And then we'll give you the tour of the bathroom. Let's see. Marilyn Skull. Love being here every day. Not a better place on YouTube. Marilyn, thank you. One of our OGs. 17 months. Thank you. I fixed it without the pressure of the live chat. I did. But oh my goodness. Can I just say, yesterday the mosquitoes were worse than any day I've ever experienced in North Carolina to date in 5 years of living here. Yesterday, I actually, there were times that I thought they were going to carry me away, that it was like there's so many on me, just like they flap their wings and I just lift up. There were just tons of mosquitoes, and I was coated in mosquito repellent too. Red Pen, I actually thought about mowing the lawn on the break. I'm like, I'd really like to get out there on the lawnmower and just give it a run, but I refrained. I'm going to let my son do that. Lucky him. That's going to be interesting live. RA builds bidet. It's going to be just attach it. It's like putting on a new toilet seat. You just, a couple bolts, connector. We've already got all the connectors. We just snap it in, boom, flip the lever, plug it in, and suddenly you have the best the bathroom has to offer available to you. Shannon, we believe people like you. That's why we're going to go ahead and do that. Probably after we get back from our trip. But Mrs. R.A. told me that probably starting tonight, I'm going to be painting the hallway. So I might have a little paint splatters on me tomorrow. All right. Where are we at? Mrs. R.A. is wonderful. I love her. She is absolutely amazing. I married up, for those of you that don't know or who doubted that. I definitely did marry up. So grateful for her. She's amazing. Great wife, great mom to our kids. Good thing about Arizona, it may be 110 out, but all the mosquitoes cook in the heat. Yeah, they're all here in North Carolina. That's why. Susie, I was actually terrified of fire ants when I first moved here, but now that I've been bit by many, many fire ants, they're not so bad. Although I say that when I'm not getting bit by them. In the act of getting bit from them, it's not fun at all, and you'll see me do the fire ant dance, which everyone knows. But for me, I've never had fire ant stings really get me. I mean, it's painful for just a brief moment, and then it goes away. I'm not sure if I'm just immune to fire ants or what. But tempted to call the mosquito squad right now. Part of the problem, I think, Debbie, is my kids have dug a hole down to the water table in my yard. I kid you not. We're elevation, I think, 60 feet above sea level here, but the water table is maybe 3 feet down, and they've dug a hole. They call it a pool, but they dug a hole in the ground in my yard without permission. So I think that's where the mosquitoes are residing right now. All right. If you do end up going to Cincinnati, take a photo in front of their courthouse. It's huge. That would be awesome to take. That's a great idea, Mary, to take pictures of different courthouses that we travel to. That'd be really cool. Bite me. Rebecca, whose job it is to count mosquitoes. Did someone say mosquitoes? Yes. And actually, the mosquito you have there, that's the one that was like, is that called a zebra mosquito or something? I think that's what we have here. They have like that white and black sort of striped. That's the one. That's the one that I saw. Happy Pioneer Day for those who are celebrating in Utah. That is a Utah holiday. Thank you, Braxton, for that reminder. Also, great birthdays, including Brooke, who may or may not be my daughter. I think May is. I don't think May not. It's just she's my daughter. So happy birthday, Brooke. We sang to her this morning. We got her a gift. She loves it. It's wonderful. All right, we are where we are in court right now. This is day 2. We're halfway through day 2. So let's go back and do a quick recap on what we've seen so far. Day 1. Just quickly, Tommy Benefield, Eva Benefield, that's the cousin and the daughter of Doug. We had the 911 caller, the neighbor, a couple deputies that responded, a couple CSTs that took some DNA samples and photographs of the crime scene or the scene. And then we have day 2, we have had Alicia Byers. This was the mom. This is how we started off this morning. First witness to be called, the defendant's mom, by the state. So she's testifying against her daughter. There wasn't really anything that came out other than just a few more details about something we already knew, that she lived together and that they were there and that she took the kid out to on her. Let's see. Alicia, who was Ashley's mom, took Ashley's child to the park to play, and that's where they were when this all went down. There wasn't much other than that, but the state did keep her subpoena. They keep her subpoena, so she still has to be separate. She can't be in the court. She can't follow along. She can't watch. Not much there. Barbara Russell, who is she says she does clinical psychology, therapist of Ashley's, and then Ashley moved in with her for about 8 months. A little strange, a little bit edgy as far as she didn't want to be there, didn't want to answer questions for the state, and then the few questions she answered for the defense were like gushing over the top smiles. It was a little much. It was a lot to take in on that one, and just an interesting situation all around. Timeline from the mom. You're right. The 5:30. The timeline we got was that on the day of the shooting, 5 p.m., Doug arrives, U-Haul arrives, mom leaves, all at the same time. That's about the same, 5 to 5:30. So he was shot after 5:30. We did also find out from Lieutenant Dan Dickerman that he arrived at 7:30 at the scene. But that's after the crime scene was cleaned up. So it was pretty quick. The body had been removed by that time. And so he did a little bit of, he was a homicide investigator. Let's see. He also gave us a timeline that Ashley was arrested in November, even though the shooting was in September, and that the U-Haul truck was there at the time. Then we have, where we left off before lunch was Stephanie Murphy took the stand. Attorney Stephanie Murphy. And it's always interesting when an attorney takes a stand. Just think back to the Alec Baldwin trial if you want to see what the fireworks can look like. But this has been very close to that. Attorney Stephanie Murphy was Doug Benefield's lawyer, his family law lawyer. So she was the one that was handling his case against Ashley regarding their child. And I think at one point even leading up to their divorce paperwork. And so she has been in the trenches and she knows all the details. Man, if you want to know something about somebody, talk to their family law lawyer if he'll break confidentiality. Oh, the stories you will hear. And she had all the stories. She had them all.
12:30 and 12:35 in the afternoon. We're back from an early lunch break that I gave for the attorneys to do some research on an impeachment issue that had arisen during the cross-examination of Stephanie Murphy. Before we get to that,
that's what we were just talking about.
Over the lunch break, I was in my office doing research,
He was on
as
YouTube.
I'm sure you all were.
He was on YouTube.
I was notified by a deputy that an unidentified female had come to the lobby of the 9th floor of the Judicial Center, had said that she is a reporter and she had information about the case and that she wanted to meet with me.
What?
And my response, and my judicial assistant, if I wanted somebody in the room. My response to the deputy was that I can't meet with anyone, but that if there was information to share, we were starting court at 12:30, that she should come to the courtroom and identify herself to the deputies
Jewel says it was
as
not
the
me.
person who wanted to speak with the court, and I would hear what she had to say in open court.
Not ex parte. Here we go.
A couple of minutes later, the judicial assistant that is filling in for my usual judicial assistant came into my office and said that the deputy had called her by phone and said that the unidentified woman had said she would not appear at 12:30, and that was it. So I'm just making a disclosure of extrajudicial matters that happen. I can give you a minute if you'd like to talk with your client and your respective co-counsel.
I would certainly like to know what it was she had to say, and I would invite her to contact me. I would make a determination whether or not it was something that I thought was worthy of being brought to the court's attention and to the prosecutor's attention.
Defense is like, hit me up in the DMs.
State, you want to be heard?
No, thank you.
State doesn't have anything
Okay.
to say.
All right, then let's finish up this impeachment argument, and then we'll get the jury.
A
At this
reporter.
point, I've asked for the jury to remain downstairs in the jury assembly room. Just it's more comfortable.
Okay, this is
Chairs are more
crazy.
comfortable. They can spread out. They have vending machines and so forth. So,
Ooh, vending machines.
all right, it's
We all want to
your
know.
objection.
And specifically, I am objecting to the manner in which the defense is trying to impeach this witness. I just want to frame the issue. This witness's character or bias based on what we spoke about before. First of all, I would say character is never appropriate for impeachment. I do have case law on point, but I think it's pretty clear that the only evidence of character that is allowed for truthfulness is reputation, and specific acts of untruthfulness are not allowed. So character, I do not believe, I don't know if the word was just used interchangeably, but I do not believe character has any part of this, and attacking character is not allowed. As to bias, I do not understand how what the defense is trying to do would achieve any bias. No ethical obligation or ethical complaint was ever filed. Even if one was filed, I don't know that that would be allowed to come in this case in this manner. I found no case law to say that that type of information could come in. But I also have objections to the manner in which this is trying to be done because, number one, Stephanie Murphy testified that the original petition for injunction had allegations in it, X, Y, and Z. Later, the defendant filed for, I think it was divorce, and alleged X, Y, and Z. I think what the defense is trying to say is that this attorney denied that allegation that was alleged in this petition after this attorney had been at Doug Benefield's deposition, implying that Stephanie Murphy knew different, but yet she still denied that paragraph of the petition. I have so many objections to that, but mainly I think even if that type of thing were allowed, this is like a motion to dismiss in criminal court where you admit a paragraph, you deny a paragraph. It sounded like she said that paragraph, number 5, was 7 pages. So I can't imagine anyone agreeing to a 7-page recitation from the other side. So I do not think it stands for what the defense is purporting that it stands for, but even if it did, I do not think it's appropriate for impeachment.
Defense?
Okay, so here's what we know. And by the way, if I use the word character in referring to this, I was mistaken, and I meant to say credibility. Here's what we know regarding Stephanie Murphy's testimony. She acknowledged that Ms. Benefield filed this domestic violence injunction petition, and she specifically mentioned a couple of the allegations. Or may recall, in particular, shooting the gun in the kitchen into the ceiling, punching the dog, and potentially suspecting that she was being poisoned. So that the court appreciates my position. The fact that she mentioned 3, my position is it opens up the entire petition. She doesn't get to limit it to just the 3 she chose to mention on her direct, because the state called her, they opened that door. It's before the jury. I'm entitled to rebut it and probe it for credibility and bias. Now, with respect to what Ms. Murphy did or failed to do, she comes before the jury and announces herself as an attorney and that she's representing Douglas Benefield. She then responds to Ms. Benefield's petition where these things are alleged, this inappropriate conduct, abusive conduct, if you will. And she denies that paragraph in Ms. Benefield's pleading, specifically paragraph 5, that Judge White lists all the horribles, the domestic violence horribles. So it's our position, and so that we're clear as to how I perceive this should unfold, she then never corrects the record, regardless of whether it's a violation of a code of conduct, which I do think is impeachable, to show bias and favoritism, and to show failure to act within her expected realm of conduct. But in addition, 27 days later, she is present at the deposition of her client, where he admits to all of these: shooting the gun, punching the dog, knocking the dog unconscious, punching holes in the wall, throwing a loaded firearm, I believe perhaps putting a tracker on a car, whatever it is, he admits to it. I am entitled to ask her why, in light of that, she never advised the trial court that her client admitted to this conduct, and why she didn't bring that to the trial court's attention. She never did. So it's not that I am particularly determined to show that she violated the code of conduct, which again I do think I should be entitled to ask, but merely to show that the trial judge, I will ask her this question also, the trial judge wasn't at the deposition. So the trial judge never knew about these admissions. Now keep in mind, this is what she's presented to this jury. I am trying to rebut that. I am at least trying to cast doubt on that witness's credibility. I have 2 cases in particular in an effort to respond directly to Your Honor's request. No, I could not find a case where a lawyer was called as a witness, and based upon cross-examination of the lawyer who failed to follow a particular code of conduct, impeachment was allowed. What I do have, however, is typical scope of cross-examination as it relates to professionals and as it relates to lay people. I want to mention the cases to the court, and then I'd like to read what I think is the relevant section. So the first one is Mendez versus State. It's a second DCA opinion. It's dated April 21st, 1982. They say in this case, page number is...
No, the whole citation.
Oh, so the whole citation is 412 Southern 2nd, 965.
Thank you.
The court says in this particular paragraph, cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test a witness's perceptions and memory, and to impeach that witness. And they cite United States versus Williams, federal case, Judge Whiting, 592, Fed 2nd, 1277, 5th Circuit, 1979. Limiting the scope of cross-examination in a manner which keeps from the jury relevant and important facts bearing on the trustworthiness of crucial prosecution testimony is improper, especially where the cross-examination is directed at a key prosecution witness. More important, and they string cite a bunch of cases to justify that, more important, a defendant should be afforded wide latitude to demonstrate bias or a possible motive of the witness to testify as she has. That's the Mendez case. And in that instance, the witness was a layperson. It was an appeal of the conviction for attempted second-degree murder of a police officer. The court reversed the conviction based on what I just read, Your Honor. I also have, Your Honor, Roosevelt versus State. It's at 42nd Southern 3rd, 293. It's a 3rd District Court of Appeal decision. It's dated August 4th, 2010, Your Honor. This was a conviction for a sexually violent predator and commitment under the Jimmy Rice Act. It was reversed. It was reversed based upon the main question on appeal is whether the trial court erred in allowing the state to impeach the defense expert witness, Dr. Natalie Brown, concerning 3 separate matters. So in Roosevelt, it was a professional witness. She was a psychologist. The state was allowed to cross-examine the state cross-examined the expert about an email that she sent while serving as a defense expert several years previously in a Florida criminal case. The state argued this testimony showed the expert's willingness to tailor her testimony to favor the party who had retained her and was therefore admissible to show bias. Here's what the court stated. Our evidence code liberally permits the introduction of evidence to show the bias or motive of a witness. Included within the types of matters that demonstrate bias are those that relate to the interest of the witness, favoritism, and corruption. Dr. Vicari's willingness to forge her interview notes at the request of the defense attorney could illustrate Dr. Vicari's corruption as a mental health expert. Therefore, because this line of impeachment could properly relate to the witness's bias, we find that the trial court did not abuse its discretion in permitting it. last case I have to cite for the court is Russ versus City of Jacksonville. It is at 734 Southern 2nd 508. It's the First District Court of Appeal, Judge White, and it was decided May 19th of 99.
A lot of argument. He's almost done here.
Remanded the ruling for a new trial because the trial court committed an error when it denied the admissibility of information relating to the prior DUI arrest practices of the defendant's city's witness. So in this case, Your Honor, it was the impeachment of an officer. Turning to the merits of appellant's argument, impeachment of evidence by the officer's prior acts. Turning to the merits of appellant's arguments, the credibility, bias, or prejudice of witnesses who testify in a case, as well as the weight to be given their testimony, are a matter for the consideration of and determination by the jury. Where the credibility and bias of an officer is brought into question by virtue of that officer's past acts, impeaching evidence of the officer's past acts is admissible. As the Second District Court of Appeal explained in Mendez versus State, which was the first case I cited to Your Honor, quote, whenever a witness takes the stand, he by that fact places his credibility in issue. Cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test the witness's perceptions and memory, and to impeach that witness. The right of full cross-examination is absolute, and the denial of that right may easily constitute reversible error. I'll be happy to show you what the cases if you like.
I was familiar with Mendez and Russ. I'm well aware of those two cases. Those come up quite a bit. And Roosevelt, you've explained it. I'm happy to take them, but it's up to you.
All right. So if the court's aware of it, I don't see any necessity. If Your Honor wants it, it's here for the court. My opportunity of Sixth Amendment right that belongs to Ms. Benefield to cross-examine Stephanie Murphy is restricted when the court doesn't allow me to probe the story that she told here today. And that's going to include, respectfully, Your Honor, my then being able to ask Ms. Murphy, so I can try to save time here for the court and everybody else. In fact, did Douglas Benefield make these admissions at his deposition when you were present? And I propose to tick them off one by one. The reason for that is the court may recall that Ms. O'Donnell asked Stephanie Murphy what she observed, not only when they did the first exchange and how pleasant Doug Benefield was, but she concluded Ms. Murphy's testimony by having Ms. Murphy opine what a gentle, kind, and decent guy Douglas Benefield was. And I have previously given Your Honor a written memorandum establishing the case law that says questions such as, well, did you know, Ms. Murphy, that he admitted A, B, C, D? Yes, you knew it because you were present, are proper questions on cross-examination. If the court disallows that, the court has breached Ms. Benefield's right to cross-examination. And I might add, Judge White, in the interest of fundamental fairness, given her testimony, I should be able to ask her that.
Wow. Strong argument.
Judge, and I'm confused about exactly what's being impeached. So apparently what the defense is saying is that because Stephanie Murphy said during the time that I dealt with Doug, he never overly expressed anger towards Ashley. I guess that's a new one. So apparently that now opens the door to showing that she knew other things. The question to her was, during the time that she was dealing with Doug and Ashley, what was his level of anger? Not what had happened before, not what she knew before. So I'm not sure that's how that opens the door when I asked her what the behavior was during the time that she dealt with Doug. So I'm not, and that's a whole different issue than all the case law we just talked about. I do obviously agree with the case law that you are allowed to impeach under the right circumstances, under the law, if the matter is relevant to credibility. I do not believe that any of this is relevant to the credibility of this witness. I believe that the defense is merely doing this for obvious reasons, trying to get in the admissions of Doug Benefield, which I dispute that he admitted things the way the defense characterizes them. So just by virtue of the fact that they're stated differently, I would disagree with their statements that he made. So I think that is what the defense is trying to do by labeling it as credibility and an attack on credibility. I think even if an attack on credibility was allowed under such circumstances, the specifics of these items would not come in. The fact that Ashley Benefield's petition for injunction listed 3 things does not open up Pandora's box where he can then impeach on the fact that the defendant admitted to those things. The court has already ruled that the state can generally talk about what the complaints were, that they were denied, and that type of thing. That's what the state did, generally talked about what the complaints were, and then that it was denied by the judge. So that's what the state did. I don't know how that opens the door to this type of attack.
Very briefly, Judge Mann.
All right, so I think from the first moment I had a hearing before you in this case, I have explained the procedures that I follow, whether it's a motion hearing, an objection, and that is the objecting party goes or the moving party goes, tell me everything you want to tell me. And then I go to the other party, the non-moving party or the party in this situation that's the proponent, and I say, tell me every argument that's in favor of you, and then I go back for rebuttal. And the reason I follow that process, and I've been very clear, and I've always followed that process, is because otherwise it'll just be back and forth and back and forth and back and forth. At some point, I have to make a decision and move on. All right. In this particular situation, as with all cross-examination, multiple factors are at play for any particular witness for impeachment purposes on cross-examination. Their perception, where they were, what they could see, what they could hear. There's 5 senses. Their memory of that, their ability to recall, their ability to communicate, their bias, any motivations they may have to testify a certain way, prejudices they may have, interests they may have in the outcome or a particular ruling, prior inconsistent statements, prior convictions. There's another number of avenues. And that's explained further in the case law. I have not been provided a case on point in this for this particular scenario. So as Mr. Taylor has astutely pointed out, whatever ruling I make may very well be the subject of an appeal to the 2nd District Court of Appeal. They may find I did something wrong or let something in I shouldn't or kept something out I shouldn't. And that's just the nature of trial work, the nature of being a trial judge and making decisions on the fly. But I'll frame this one up as best I can so it's ready for the appellate court. I find that the current avenue of impeachment of Ms. Murphy is improper. I'm going to sustain the objection. I find that it is improper impeachment to attempt to get in the victim's statements made in a deposition in a civil case unrelated to the criminal case through the impeachment of his attorney in the civil case based on an allegation that she violated a rule of professional conduct by not amending her answer to his complaint when it is alleged that she subsequently became aware of contrary information. I find that it doesn't provide any basis for impeachment under the existing case law, and this may be the case that says it does. All right. So are we going to bring the jury back in?
Yeah. Yes.
I would have loved to see this
just so I understand.
continue, but
I'm precluded from basing my cross on the failure to conform to the professional code of conduct. Am I likewise precluded from probing her statement that Doug was a gentle individual and that the complaint that was filed was unfounded? In fact, if the court report played it back, that was her characterization, that the allegations by Judge Moreland were unfounded.
I sustain that objection. So, sustained. Are you ready to bring the jury back in?
Yes, but
that
you need
part,
the witness
that
on the
part might
stand.
come back.
Yeah, I'm just asking right now,
yeah.
Are you ready?
Yes.
Are you ready?
Yeah, I would like to first make a motion. I move for a mistrial. I move for a mistrial based on the court's absolute and consistent denial of Ms. Benefield's right to cross-examine, and at every turn the court's ruling adverse to the defense, despite the fact that the court has, under the same circumstances, allowed the state to be able to pursue it. I think individually, perhaps, it could be argued that they don't reach the level of reversible error, but I think cumulatively, especially given the state of mind that the court displayed in writing the order denying the standing your ground, where Your Honor fully stated that Ms. Benefield was guilty, I think we are seeing the result of that, and we are being denied not only the right to cross-examination, but the right to a fundamentally fair trial.
Would you like to be heard?
Yeah.
I think that was too much.
Denied.
Denied.
You ready to bring the jury in?
Denied.
You ready to bring the jury in?
Yes.
All right, can you have Ms. Murphy step back in, please?
Okay. The judge looked at the end run. He looked at what they were trying to accomplish with this, and he said, bringing those statements in, I don't think that's right. He said, I don't have any case law to base this on, but it just doesn't seem right. And so I'm going to make a ruling and let it go up to the appellate court. But this is my ruling and this is my reasoning. And I like that, even though I disagree with some of what he said. Witness is coming back in here. The response by saying, I move for a mistrial. Yeah, he's preserving it for the record. But I think he already had the record preserved as far as appeal goes. You know the judge is not going to grant that just because the decision goes against you.
All right, Ms. Murphy, if you could resume your witness seat.
We're going to resume the objection
And I
counter.
will remind you, you're under oath. I also need to ask, did anybody at all speak with you about your testimony or the questions asked? Did you speak with any of the attorneys?
Just a
Did you
reporter.
speak with any other witnesses about questions they were asked or the testimony they gave?
No, none of those.
Did you watch any of the proceedings?
God, no.
Pull up.
Marilyn Skoll, love being here every day. Not a better place on YouTube. Thank you very much, Marilyn. Appreciate that. Wonderful having you here. at the beginning of court, either or after a break, it is so noisy as everyone's getting their papers in order. The mics are right next to the papers. I apologize for that. The witness that just took the stand is still under cross-examination. Stephanie Murphy. Judge just sustained the route of impeachment that they were going for. I think the defense is still going to test the waters to see the limits of what he can probe here. So we expect a lot of objections and maybe the judge coming down on the defense. Courtroom's filling up. A lot more people here this afternoon than this morning. Test 1, 2, test 1, 2.
All right, y'all can have a seat. Welcome back, everybody. Hope you beat the crowd for lunch. Did anybody discuss the case amongst yourselves with anybody outside of this group? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
All right, everybody says no. When we broke for lunch, Mr. Taylor was cross-examining Ms. Murphy. You may resume your cross.
Thank you, Judge White. Ms. Murphy, we've pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay. And then you've told us here today that Dr. Broder's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is...
Objection?
Overruled.
So, I'm sorry, Judge, was that overruled?
Overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. Broder's report.
Are you asking if that's what I believe or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms. O'Donnell.
Yes, I did a discovery request.
And so is the implication not that, as you testified before the jury earlier, Ms. Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. Broder 3 days later?
Absolutely, I have no doubt.
Okay, so that's the theory of the homicide.
Right.
All right, so I want to pass you some emails, see if you recognize them.
Should we approach?
Yes.
That was Sarah on the phone again. Those who know, if you know, you know. I hang up on her. Why did we kill that? Did they approach? It's a full-on waterfall in the courtroom too, Tiki. It is just the mics are so sensitive. The walls, the sound just bounces around. It's a terrible audio environment. Yes, there was an objection. Okay, thank you, Melpoy, keeping me honest. Up to 89 now in this case. Most of them coming today. Ashley, listen intently. I think when they approach it is an objection because they're stopping what he's doing for a reason, and they're saying why. So it's a fire sale on objections. Get them while they're hot. Yeah, it's happening like crazy. Yes, this is in Florida, Mary, or who was asking? I forget. Which Ivy. This is in Florida. We're in Manatee County. Florida. I didn't count the motion for a mistrial as an objection. I probably should. I'm going to count that one. I gave it some thought, and you can, maybe the appellate court will overturn my decision, but I'm counting that as an objection right now. Do you take notice every time the defense calls it the homicide? Homicide is the manner of death. Homicide
So I would
can
like
be justified.
to pass these documents to you and let you just take a look.
She has her glasses out. She's very pleasant, at least
Take
on the
your time.
surface. Oh my goodness, she is literally taking her time. She's reading every bit of it. She stopped reading. It sounds like we're all just conversing out by the fountain in the park. It sounds like water in the background. Denied. Denied you, Braxton. I don't know who's drumming. I think it's probably the defense attorney is my guess. Today's trial is sponsored by the Rainforest, apparently. Now that I think we've entered the team drumming segment, we have two drummers. Selena gifted a membership. Thank you very much, Selena. Went to Miss Williams. Mrs. Williams, congratulations. This is a strong witness, and we're getting some really spicy exchanges as a result. Vicky, thank you for the super sticker. Vicky Kennedy, thank you.
Okay, so I have a series of simple questions for you. Do you want to reconsider whether or not the release of Dr. Broder's report was set for 3 days following the incident?
It was agreed with.
Do you want to?
No, I'm not going to revisit that.
You can answer and then explain if you like. I'd like you to first answer.
Okay. I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further if you want to hear more.
Welcome, Stacey Ray Barnes.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust?
It does. I don't think it's a complete conversations, but yes.
Yeah, okay. Now, is it not a fact that Dr. Broder, on the 3 days following the event, was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and...
Objection. Relevance.
Ooh. Does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant.
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report.
Dr. Broder was returning from his vacation on the 23rd. So if you look back through the emails.
Not responsive to my question, Your Honor. She's editorializing. I asked her for a simple answer. She can feel free to explain it after if the court feels that's appropriate.
They're both objecting.
Also stated, it called for a yes or no.
Well, and that's why I'm saying she's, okay.
No, it called for a yes or no, so
okay.
Your objection
Is sustained. Got it. All right, so is the answer to my question yes?
Can you repeat the question?
I knew you were going to ask me that.
Well, I want to be accurate.
Can the court read
Can
it
I
back?
ask the court reporter, Your Honor, to read the last question back?
He forgot it.
Go ahead, ma'am.
And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report?
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place?
Had he been alive, yes. On the 30th, not the 23rd, yes. Which is what I think you're confusing.
You referred to a letter that you sent to Ms. Benefield on March 14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
I do not.
Okay, this is not the letter that I sent. This is a draft of a letter. Mm-hmm. The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on the 15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct.
Defense is losing here. The witness is winning.
That's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify, but there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. It was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to have a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
I do.
Oh, that would help if I could see it then.
May I, Your Honor?
You may approach, yes.
We're listening to cross-examination of Stephanie Murphy, who is the victim's lawyer. And it's spicy. She has all the details. These two have fought it out before.
What is the date of the transcript?
Well, the date of the hearing was November 3rd, 2017.
November 3rd. And you were aware that the order was entered for a period of 6 months, correct?
I wanted to, didn't you hand this to me for me to look at?
Sure.
Okay.
She's like, shut up. I'm reading. Oh, my goodness. Both of them are lawyers. They're playing a game, and they're hitting each other and punching each other with blows that the casual observer might not even know are happening. But I love it. Oh, my goodness. Yeah, she's not getting pushed around. She's not. She knows that the objection was sustained because the line of questioning stopped. So she knows she's on more solid ground, that she's not going to get hit in that area where she, it might have had a little weakness there. So she knows the judge backed her up a little bit.
Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
This is the pinned message at the top of
It
the
appears
chat.
so, according to the order that was entered
And
10 days later.
If you look at the last page, I believe paragraph 2, the judge orders.
I'm going to object to going through this hearsay piece of paper.
Are we only talking about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay, the order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has sufficient experience, training, and knowledge.
All right. So the hearing concluded on the 3rd.
It appears that it did. I wasn't there.
Yeah.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that it was a formal request, not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
Sustained.
About to hit the triple digits.
Let me pass to you, if I can, this document.
Did you see it?
I did not. I don't know what
I need you to show it to opposing counsel before you show it to a witness.
I thought she had a copy.
She might have a copy, but she still wants you to show it to her. And that's proper procedure. Jury's not here for this. Oh, wait, jury is here for this, right? The jury's back. I'm sorry, I thought for some reason they weren't, but they're here. It's not a proffer.
Miss Murphy, is it not a fact that you knew on September 18th of 2000 that the only matter being heard 3 days later on September 20th was the injunction, not the release of Dr. Broder's report?
Now, I think you're getting the dates confused again. So this was September 18th, was this email talking about the judge setting a hearing on September 23rd. Because in this email, she did say the only matter being heard on September 30th is the injunction. That changed after this time. And you don't have those emails, apparently.
Do you?
Well, no, I don't have my file with me. 3 boxes worth of documents. But before we even went to mediation, it was agreed and the court was advised that we were going to be addressing only the joint motion for the release of the psychological evaluation.
Which was not said on that day, correct?
You mean the 23rd, which is what they're talking about in this email?
Yes.
Right, it was not said on the 23rd. Dr. Broder was on vacation.
Okay.
It was going to be said on the 30th.
It's the victim's lawyer who's
Did
on the
you know
stand.
whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing. I know Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank you for adding that. Let me just ask you a question. What is it about you may not contact Ms. Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it, so enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told. And we had the time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
Okay, so this report by Broder, the one that you acknowledge and the state suggests is the theory behind the homicide, Ms. Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in the family law court. So I don't know what she signed.
She voluntarily participated.
You know, I don't know. You're going to have to talk to the Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in a family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You're not aware of any commandment that either Mr. Benefield or Ms. Benefield participate in Dr. Broder's evaluation?
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
It's a murder trial. Ashley Benefield's accused of shooting and killing her husband in cold blood. She says, the state says, she says it was self-defense.
Yes, sir.
This was her husband's lawyer. Defense lost this one. Mr. Taylor goes back to talk to Mr. O'Keefe, his paralegal. Get a few questions and notes. Mr. O'Keefe is on the ball. He sort of runs the show from behind on his little desk.
Please.
This is the best advertisement that Stephanie Murphy could possibly do for her law firm. It's this testimony. She's killing it up here. She's holding her own.
Are you asking for a moment?
Yes.
She's holding her own, and that's. I think that's why the state stopped objecting, because she can defend herself and she can get stuff in better than the state can, because she can do things the state cannot do, prosecution cannot do. I only know about Florida. or maybe South Carolina. We are flying through the witnesses. We've already had, let's see, this is our fourth witness. We're halfway through the witnesses today. We should have a total of 4 more. Turn it down just a bit. Those papers are so loud. That is our friend Jules, our court watcher in the courtroom. She's watching. She's been calling us during the breaks to let us know what's happening that we can't see. It happens off camera. Attorney Murphy there in pink is, or is that fuchsia? I think it's fuchsia.
One last shot at this.
She's doing a great job.
Can I see the document?
Yes, same document I showed you.
Oh, the same one from before?
Yeah.
Okay.
Does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you
Is the answer to my, well, let's get a simple answer. Is the answer to that yes?
I don't have the docket, so I guess the answer is I don't know what the docket says. All I know is it was scheduled for the 30th.
Objection, Judge Leonard, answer the question.
You try to make this.
All I know is that that was supposed to be addressed on the 30th of September.
And were you not told on the 30th September that the only issue that would be heard was the
Objection asked and answered.
Was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
Yeah. And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong?
Objection, compound question?
And that the only matter being heard was
Objection,
not
compound question?
Was not the domestic violence injunction.
Sustained.
Do you have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide emails.
Do you have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
you should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case.
Objection, badgering.
Go ahead and answer your question.
That the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us?
Sustained.
That was badgering.
That's all.
Oh. Don't, sir, you have one more paper. Mr. Taylor, don't forget your paper.
I'd like to approach also.
And we approach.
All right. Redirect.
Are we finally going to redirect with the witness?
She's under ours. No questions, thank you.
No redirect.
Can this witness be released?
Yes.
Absolutely not. She's under our subpoena.
All right. Ma'am, you remain under subpoena. As I said before, same rules on
absolutely not
sequestration. So you cannot discuss the questions asked of you or your answers with anyone, including the attorneys. You can't talk with any other witnesses about what happened in court or what their testimony was or the questions asked of them. You can't do anything that's going on.
I don't think I was subpoenaed by Mr. Taylor's office.
Okay, well.
She's released from Mars.
All right. Commissioner Jury, can you step out, please? I'll answer this legal question. Don't begin your deliberations or talk with anybody outside the jury. Don't do any research on people, places, things, or legal topics we've heard anything about.
I don't believe the defense subpoenaed me, Your Honor, so they don't have anything to hold me. This is a ballsy little move there, and she would know. It's a loophole, yeah. He's going to subpoena her now. How fast can he get a subpoena written?
You all can have a seat.
Well, is she going to sit in the courtroom just to spite him? Mildred, thank you very much. This is a cage fight. This is like going 12 rounds.
Subpoenas for depositions and trials in the old days had to be procured from the clerk, which is obviously a branch of the court. That was changed many, many years ago to allow attorneys to save time and effort and money for everyone involved, where attorneys of record were granted the authority under the Florida Rules of Criminal Procedure to issue subpoenas for deposition and trial. I would imagine if we pull them up, and I'd be happy to take a look at it, I would imagine that the subpoena that was issued is for the court.
I would have to look at this.
Kathy, thank you for gifting this.
My position is when a witness is subpoenaed to court, and the reason I ask each and every time, can this witness be released? It's because I believe witnesses are subpoenaed by the attorneys on behalf of the court. So whether you were subpoenaed by the state or the defense is of no moment to me. I asked, could you be released from a subpoena? The state said yes. The defense says no. That's all I need. So, Ms. Murphy, you are not released from your subpoena.
Thank you.
The obligations regarding the rule of sequestration in Florida statutes applies to you.
This judge is winning me over.
Thank you.
I don't agree with everything he does, but his rationale and his approach seems very fair. I'm really liking it. Jury is out right now. Wow.
All right, the witness has been excused. Mr. Taylor, you wanted to approach, but the jury's out, so I figured might as well just take care of it now.
Sure. So now I would ask that the court issue a subpoena to Judge Moreland's clerk. The court may recall that we had an in-camera hearing where the court quashed the defense subpoena to Judge Moreland's JA and told me that there were better ways that I could prove my case and that the court shudders to think what would happen if every JA were subpoenaed. What the court's just witnessed is Ms. Murphy lied flat out about the reason why Ms. Benefield feared release of that report, and my impeachment of Ms. Murphy indisputably is going to come from Judge Moreland's JA, who told Ms. Murphy in the emails that I handed her and showed her the only thing that is set for hearing on September 30th, 2020 is the domestic violence injunction. Nothing else will be heard. In fact, I'm going to read for the record I'm going to read the one-sentence email that was sent.
The reason I'm going to stop you at this point
because it's
is
denied.
You're referencing arguments that were made in camera. The state was not present at your request in order to preserve trial strategy of the defense.
It was ex parte?
Present at that hearing, when we stepped back into the jury room, was myself, a court reporter, Mary Ann Floyd, the general counsel for the 12th Judicial Circuit, Mr. Taylor, and Ms. Benefield. The state was not present. They didn't have an opportunity to be heard or know these issues. Now the issues are being brought to light. In order for them to have a fair opportunity to understand the issues and be prepared to argue against whatever motions the defense may make, I certainly think due process requires they're entitled to notice and opportunity. I would do the same for the defense if there was some issue for whatever reason that I had considered in camera or ex parte for the state, and whatever reason the need for the privilege or confidentiality no longer existed, prior to having a hearing on that issue and requiring the defense to respond to it, I certainly think, at a minimum, notice of the issue and an opportunity to be heard. So right now, they don't even have a copy of the order that I signed that you just quoted from, Mr. Taylor, and they have no idea what you're talking about because they have not seen that order because I ordered it to be sealed.
Yes, if the court will allow me, I'll elaborate. And I
He
would
just
like to
quoted from
read
his sealed document in
the
open
email
court.
in particular.
The issue that you seek to have heard right now, I am happy to hear it. However, it is not a pressing matter. You seek to have a witness subpoenaed in order to present, I would assume, during your case in chief.
Yes, sir.
We could certainly address that issue at the end of the day after the state has had a chance to review that order, and I don't recall if the motion. No, the motion itself was public, but then we had the in-camera hearing, and my order was I sealed it.
Yes, sir.
So
that's
We
a lot
have
better.
the email chain also as an exhibit.
yes, so the email chain is an exhibit. There were two exhibits actually. I can't remember what the other one was, and then we had my order. So I'm going to need to unseal those things so you you can get copies of them.
I remember what the other one was. It was her prior testimony from the stand your ground hearing.
It was excerpts from the stand your ground hearing, excerpts
We're gonna
of
open that
Ms.
up.
Murphy's testimony. That was exhibit 2.
Correct,
Or
saying what she said today.
Okay.
So
DSN, thanks for the gift of membership.
that I want to supplement today's record with is I showed Ms. Murphy an email dated September 18th of 2020 at 10:18 a.m. included between her and the judicial assistant for Judge Moreland, and it says as follows: Good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only matter being heard on September 30th is the injunction hearing.
And that is part of the email string that's one of the exhibits.
Yes, sir.
All right. So like I said, I don't think it's appropriate to hear this right now. I think the state has every opportunity and should be allowed to review my order and the two exhibits.
Judge, may I just be heard real quick?
I'm sorry?
Can I just be heard briefly on
Of
something?
course.
Now, or do you want me to wait?
Go ahead.
Okay. I don't know if, because I'm unsure what Your Honor is referring to, because we haven't seen it, the seal, I don't know that any of the things that Mr. Taylor just showed to Ms. Murphy were ever provided to the state in discovery, which is one issue. We received a defendant's exhibit list that was unnumbered and in no particular order. It has 391 items on it. I spent more time than I should have trying to organize it in some fashion, and I do not believe that any of those emails were ever provided to the state in discovery.
Wrong.
If they were, I'm still speaking, sir. If they were,
wrong.
I would just ask if somebody could give me the name, because I numbered them, but it has 391 items on it, and it's some of them have multiple things inside of them, and they're not named anything that you can understand. So I'm just asking that if in fact they were provided, if we could, the items that were shown to Ms. Murphy, in addition to what Your Honor has said, then seal, please.
All right, I'll let you two work on that, and I will look forward to having a Richardson hearing at the same time that we have the hearing on the defense request for me to reconsider my order quashing the mechanic trial subpoena.
Oh my goodness. This is crazy. A cage match to ensue. This is so wild. Is that the judge typing? Or playing a Congo? Richardson hearing has to do the notice of discovery, saying, hey, we didn't get this document, so the first we've heard about it is here in court. A discovery violation like that can bring about sanctions. It can lead to the exclusion of the data, of the information. It can lead to various different sanctions, whatever the court deems is necessary. Exclusion of a witness, all sorts of things can happen if there's a discovery violation. So the Richardson hearing will reach that. That's what happened to Baldwin, but this is the other way around. This is the defense not provided to the prosecution until they basically showed it to the witness. That is the judge drumming up there, just pounding out a rhythm on the Congos. Wow, what just happened? This is spicy. This is spicy because we had we have four players that just were playing in court. We have the prosecution, defense, the witness who was a lawyer, and the judge. The judge is playing referee, and he is shooting straight. He's really doing a great job on this. I don't agree with everything he does, but his rationale is sound. He stands by it. It seems like he's being fair in how he applies his reasoning. We get a witness on the stand. It was Stephanie Murphy. She's off the stand now, still under subpoena, but she's off the stand. And she takes the stand. She is Doug's lawyer. Doug's the victim. Doug is dead. Doug was the one who was shot and killed by Ashley. We know that happened. That's not in dispute. Ashley says it was in self-defense. Ashley's lawyer has been trying to bring in statements that Doug made in a civil case, saying, I shot a hole in the ceiling, I punched a hole in the wall, I punched the dog until it was unconscious or something. Some really bad stuff, okay? Bad things about Doug. He's trying to bring these into court. They're not admissible. And so he's trying this backdoor way to get it in, and he tries to get it in using his lawyer who filed something saying that he was a good guy and always calm, but then the lawyer knew that he had made these statements, and he's trying to get this hearsay statement in that way, and he didn't get him. And he was getting frustrated and angry, and the fight just went on and on. You could tell the lawyer wanted to fight as well. She had a dog in the fight. Her victim's dead. As she put it, said that before your client killed my client, was her words. So she gets up there and she's sort of holding her own. Even her parting words as she's leaving the stand was that, the defense didn't subpoena me. They can't hold me. The state released me. I'm done. And I think the judge is wrong on that one. His view is different than what I've seen in any other court. I don't know Florida law specifically. Maybe Peter Tragos, lawyer, might be able to shine some light on that specifically because he practices law in Florida. But a subpoena is for a side. That side subpoenas their witnesses. The judge says, I view all subpoenas as if they're for the court. So he held her under subpoena. But yeah. Interesting stuff. Judge has a great memory. The witness had a great memory as well. Really enjoyed that. We've got a spam call now. We have a spam call now. Hello, is this Sarah? Hello? Hello? Apparently wasn't Sarah. So this ended with the defense saying, I'd like to, well, in the middle there was a motion for, I guess, mistrial, which was denied. But the defense filed a motion to subpoena the judicial assistant of the judge in the civil suit to bring her in to testify about the emails.
I just prepared and sent to the clerk an order unsealing the prior order quashing Vicky Mechanic's trial subpoena, unsealing the 2 exhibits that were admitted by the defendant during the in-camera hearing.
Make your request now.
And unsealing the notes and transcripts of the court reporter that was present for the in-camera hearing. I'll sign that right now. That'll should happen pretty quickly, and State, you'll be able to get copies of that, and we'll see if we can have this argument by the end of today.
The public should be able to get copies as well.
Before we get started.
Make your document request now.
On the defendant's request, Ori Tennis motion to reconsider order quashing, and the State's Richardson hearing.
The Richardson one's going to be spicy.
I can state the other ones.
Lenova, thanks for gifting a membership. Thank you very much. Big supporter of the channel. So now we're bringing in some witnesses connected to the previous hearing, which was previously sealed. This is. I'm not sure if it's going to play out tonight. We might have the Richardson hearing tonight, but the actual testimony, the subpoena, and the judicial assistant, and everything else that might come in during the defense's case at some point, which will start Thursday, maybe Thursday morning, midday.
There's one for the State, and one for the defense.
The judge's like, I'm opening the books. Everything's out in the open. Go for it. Have at it. The State doesn't need to have a huge argument. Their argument they need to focus on is for the Richardson hearing, on saying this was never provided to us. It should have been turned over, and that could keep it out right there if the judge rules that it was a violation.
All right, State, call your next witness. All right, who is your next witness?
Oh, Detective Chris Gillum.
All right, go ahead and bring the jury in.
Detective Chris Gillum. Next witness, witness number 1, 2, 3, 4, 5 for the day. I thought we were going to get 8, so we need to pick up the pace a little bit. Get those dogs. Amber, I know you're busy. Can you keep an eye out for those? Jury's entering.
All right, y'all can have a seat. Welcome back, everybody. As you're finding your chairs, anybody talk about the case back in the jury room, talk about the case with anybody outside the jury, or do any research on any of the things we talked about? Everybody says more. State, call your next witness.
Detective Chris Gillum.
I don't think Canton's meeting tonight.
Is there a firm testimony about to give the truth, the whole truth, or the truth?
I do.
Amber, I knew you'd be on that one. She's one of our great document hounds.
Hello, sir. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right as you need. And just speak in a loud, clear voice, and it should pick up everything.
Yes, sir.
Good afternoon.
Good afternoon.
Please state your name.
Chris Gillum, Gillum.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
22 years.
And did you work somewhere else before for several years? How many years?
Yes, City of Palmetto Police Department for 12 years.
Okay. And what position do you currently hold at Manatee?
I am currently a domestic violence investigator.
And how long have you been in that unit?
12 years.
How, I said in that unit, but if you could just describe, does Manatee County Sheriff's Office have a unit for domestic violence?
Yes, we do. We have 4 detectives.
Okay. And where and how is that unit housed?
We are housed at our building is the 3500 block of 9th Street West is the actual address. And within our building, it's my unit and the Crimes Against Children detectives as well.
Okay. Were you in that same position back in 2017 to 2020?
Yes, I was.
Okay. Back then, did your department house child protection services?
Yes, at that time we did.
Okay. And explain that. Were they with you in the same area, or how did that work?
No, they were on the other side of the building. We had our own area, and they were on the completely opposite side of the building.
And were they actually employees of the sheriff's office?
Yes.
Okay. Did you do a lot of stuff with them together? A lot of investigations together?
The domestic violence unit, we did not. Every so often, that was mostly the Crimes Against Children detectives that worked with them.
And as a domestic violence detective, have you investigated violations of injunctions and that type of thing?
I certainly have.
Okay. Now, sometimes when someone is asking for an injunction, or when an injunction is violated, it can be charged criminally, correct?
Correct.
Okay. Or they can take other avenues
That's
to address
correct.
the violation. But you're not involved in that other avenue if it's a different court, correct?
Yes, I'm not involved in that.
All right. Did you become familiar at some point with someone named Ashley Benefield?
I did.
And when was that?
December of 2017.
Okay. Generally, what were the circumstances, without it getting into a lot of detail?
She reported that her husband violated an injunction that was in place out of South Carolina.
Okay. And that came to you?
Correct.
Right. And we've heard several mentionings of poisoning. Did this have to do with the same issue?
It was the same case, yes, but I had nothing to do with that investigation.
Okay. So the poisoning itself, you didn't have any contact with. It was just the violation of injunction.
Correct.
Okay. Did you speak to Ashley?
I did.
How many times would you say you spoke to Ashley?
I think a fair number would be 30 to 40.
Okay. And generally speaking, was that because you were contacting her or she was contacting you?
No, she started contacting me on a regular basis beginning around February of 2018.
Okay. And what was she contacting you about?
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when you do a violation of injunction, when you're investigating a violation of injunction, you can do several things, correct? You can, well, explain what you can do with it.
We can make a physical arrest in the case. There could be no charges filed in the case, or we can send the case to the state attorney's office.
Okay. So if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough for charges to be filed in this case.
Okay. So it sounds like there's no charges and then arrest and...
Sustained.
So you said Ms. Benefield was calling you asking about the arrest of Mr. Benefield?
Yes.
Okay. And what did you tell her?
That the case was still suspended at that point, and when I had an answer for her, I would let her know.
Okay. And so that was the beginning of your conversations?
Yes.
Right? So, did she continue to call?
Yes, repeatedly. Twice a week at least.
And speak to you personally?
Yes.
And what was her comments? What were her concerns?
It was the same thing. When was Doug going to be arrested for violating the injunction?
Had you ever told her that he was going to be arrested?
I did not.
Okay. At some point, did you decide to forward the charges?
I did.
And is that to the state attorney's office like we talked about?
Yes, it is.
Okay. Did you inform her of that?
I sure did.
Okay. And what was her reaction to that?
She was upset that he was not being arrested.
Okay. Were you able to explain to her that the process and how this was going to go?
Sustained.
Were you able to explain the process to her?
Yes, I was.
Okay. And how did she take that?
She was not happy that I was not placing Doug under arrest.
Okay. At some point, did you speak to Ashley Benefield again, and she told you about a court hearing?
Yes.
Okay. Approximately when was that conversation?
Around the first week of May 2018.
May 2018. And what did she say?
She just got right into the phone call and requested that I arrest Doug for a hearing that was coming up in Manatee County.
Okay, you just said arrest for a hearing.
Yes.
But arrest at a hearing?
Yes, there was a upcoming hearing in Manatee County.
Okay. And was that hearing involving your case or something else?
It was something else. It was not my case.
Okay. Did you know that there was a hearing or there was even a court issue going on?
I did not.
So she told you there was a court hearing, and did she tell you when it was?
No, that just shows there was an upcoming hearing, and she asked for me to arrest Doug when he came inside the courtroom in front of the presiding judge.
Okay. And what was your reaction to that?
That absolutely would not occur.
Okay. And how did she take that?
She was upset. And at that point, I would call it a dramatic cry, hysterical cry, started happening. And I'm still informing her, we're not going to do that. We're just not going to arrest him in the courtroom. And she made a comment, something to the effect of, if the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement. And I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And I'm trying to explain to her gently, that's just not going to happen, especially not going to happen for a judge to see to help you in a civil matter.
And did you, in fact, explain all that to her?
Yes, I did.
And how did she react?
We went back and forth 5 minutes or so. Her just kept requesting to arrest him. I said, this is not going to happen. And her tone turned from the crying to very aggressive, and she says, you will effing arrest him in front of the judge, and I will make sure you do it.
What did you say to that?
I started pushing back a little bit, and I said, it's not going to happen. Whatever you say or do, you cannot make me arrest somebody in front of a judge, and it's just not going to happen.
And what did she do?
I guess she started crying again, and came out with a comment, something to the effect of, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
And that hadn't come up in this phone call. The phone call dealt with me arresting Doug in front of a judge, and then it turned to not arresting him and allowing me to let him kill her and the baby.
Okay. So that seemed kind of different to you?
Yes.
Than what you had previously been doing?
Yes.
Okay. How long did this conversation go on?
20 to 30 minutes.
Okay.
For up to that time, it's probably 20 to 30 minutes.
Okay. And during this time, excuse me, did the defendant ever seem to understand the process of what you were saying?
No.
Okay. And at some point, did she change from crying again?
She did.
What did she do?
It just abruptly changed, and she let out like a screech or a high-pitched scream, and she says, I'll do whatever I have to do to kill my baby, or keep my baby, you a-hole.
Okay. So it's a high-pitched scream, or did you say scream or screech?
Like a screech at first, but it was I'll call it a screech.
A screech.
Yeah.
And tell me, what volume is this?
Just tell me we have body cam.
I could just say it's a very loud, maybe top of lung type scream.
Okay. Could you demonstrate to us?
It's impossible. There's no way I could.
Why would it be impossible?
I couldn't get my voice that high. There's no way.
So
could you demonstrate?
It was loud and it was high.
Yes.
And she said, can you repeat what she said?
I will do anything I have to do to keep my baby, you a-hole.
You a-hole. And did she say a-hole?
No, she said the full word.
Okay. And after she said that, what'd she do?
At that point, I had checked out of the phone call, and I was pretty much ready to hang up the phone on her. And she accused me of conspiring with Doug to get her baby taken away.
And had you even spoken to Doug about custody of the child?
No.
Okay. Were there other detectives around you at the time of this phone call?
Yes, there were two other detectives.
And do you recall their names?
Oh, yes. Detective Patricia Hetrick and Detective Brian Moreland.
And did they appear to recognize that you were on a difficult call?
Oh, they did. And at one point, Brian even asked me if I needed some help.
Sustained.
Hearsay.
And at some point, how did the phone call end?
Miss Benefield terminated the phone call.
Okay. And you seem to have a good memory of this call.
Yes.
And
why is that?
Why do you have a good memory of this call?
Because in my 12 years of doing this, I've never had anybody ask me to arrest someone in front of a judge inside of a courtroom. Now, I have had people call me before and say somebody may be appearing in court that I'm looking for so I can arrest them, but I've never had somebody say, wait until he's inside the courtroom in front of the judge.
Man.
Thank you. No further questions.
Cross?
How do you salvage that defense? That's some pretty pointed testimony.
Afternoon, Detective Gillum.
Good afternoon, sir.
I want to ask you a few questions about report writing.
Sure.
Do they teach that to you in police academy?
Sure. Back in 1989, they did, yes.
Okay. It's obviously an important part of police work.
Sure.
How many cases would you say could you average that you handle in a month?
20.
Okay. And over the course of a year, we're talking about
one a day.
300 closed.
Mm-hmm.
One a day for work days.
So, are you familiar with the saying that they give you in police academy, if it's not in the report, it didn't happen?
I've heard that before, yes.
All right. And that's because the report is obviously more reliable than your memory.
I could understand that, yes.
All right. At 20 cases a month, 2.5 years later, you're into like 600 cases. If you got your report, you can refresh your recollection rather than have to recall off the top of your head.
Sure.
Which is why you want to put critical details in your report, because that's what you want to remember.
Correct.
Not necessarily that somebody had on mismatching socks, but that they had something that's significant to the investigation.
Sure.
All right. So your initial involvement, you told us in the case, is speaking with Ashley Benefield on or about May 31st of 2018 regarding the domestic violence injunction in South Carolina.
That wasn't the first time I spoke with her, no. There were several incidents I spoke several times I did.
Did you speak with her on or about the 31st of May?
I was prior to that.
Okay, about the South Carolina injunction.
Yes.
All right. And just to be clear, we're talking about the same thing. There was a court that had issued an injunction in South Carolina, stay away from one another.
Yes, in South Carolina, that is correct, sir.
Okay. Now, at some point, did you bring any of the reports that you wrote with you here today?
I did.
Do you recall how many you wrote?
Supplemental reports, 3 or 4.
Yes. All right. So initially, if I can ask you about the sequence of these events, Miss Benefield had gone down to the Manatee County Sheriff's Office to complain about a package that she received because it came while the South Carolina injunction was in effect.
Yes.
All right. And it would have been Deputy Wesley Weber, to your knowledge, had requested a capias based upon Ms. Benefield's receipt of that package.
Correct.
Just so the ladies and gentlemen of the jury understand, a capias is an arrest warrant.
It's testifying, and
Sustained.
it's all hearsay.
What is a capias?
A capias is information where a deputy believes that there's probable cause for someone's arrest.
All right. And that was issued by Deputy Wesley Weber.
Correct.
And that would have been on December 14th of 2017.
That sounds correct.
Now, a month later, well, actually, several months later, on May 31st of 2018.
Objection, Judge. The call's for hearsay, but I apologize. I wasn't finished the question.
Did you write the first of your supplemental reports?
Yes.
And in that report, you stated that Ms. Benefield...
Objection. Hearsay.
Sustained.
In the report, did you indicate...
Objection, hearsay.
Sustained.
Did you write anything in your report in describing?
Objection, hearsay.
Can you approach, please?
Hold on. Let me have one more shot at it.
I don't think.
Did you document in your report anything different than you told us here today about how you characterized Miss Benefield's demeanor?
I didn't go into any details in that supplement at all, in that one.
May I show him the report?
Took him a while. 6 attempts. Pressing the objection button is my exercise for today.
Yes.
We're going to approach anyway. Sound down for when the sound comes back. This is crazy. Oh, man. Okay, this officer had a phone call with Ashley Benefield that was apparently the gist of the conversation was that Ashley wanted Doug arrested in court. Like that was where she wanted, not just now, but like when he shows up to court, the judge is sitting there, you walk in, put him in handcuffs, haul him off to jail. That would be great for my case, so I can keep my baby. When the officer said, no, that's not how it rolls, we're not going to do that, she started crying. She got a little manipulative. He says he was screeching. Sadly, I was hoping that he would say yes and make an attempt, but he did not attempt to replicate the screeching noise she made. That would have been epic courtroom footage if he had. But man, their defense is doing everything they can to try to discredit this witness because he has some things to say about Ashley Benefield that are not very complimentary, that she seems to be quite an angry person, especially when it comes to Doug, according to the officer. So, we're back. Turn up the volume again.
During that time, Detective Gilliam, back in May of 2018, you overrode Deputy Wesley Weber's capious request, correct?
I did.
Okay. And you put the case on an inactive status?
Yes.
And I think you decided, as you told us, it would be submitted to the state attorney's office.
That is correct.
Now, on June 5th of 2018, you interviewed Douglas Benefield, did you not?
Correct.
And he admitted to you.
Objection, hearsay.
Sustained.
What was his position with respect when you asked him?
Objection, hearsay.
Finish the question.
Did you send the package to Miss Benefield?
Sustained.
Did you make a determination from your conversation with Mr. Benefield whether or not a package had been sent to Miss Benefield?
That's a good question.
Objection, relevant.
Overruled.
Can you ask the question again, please?
Sure. Did you make a determination as a result of your investigation whether a package had been sent to Miss Benefield?
Yes.
Did you make a determination as to who sent it?
Yes.
Who?
Douglas Benefield.
Did you make a determination of what the contents of the package were?
It was a T-set.
And was hazmat called?
Objection, Judge. Hearsay.
Sustained.
Did
you say hazmat?
Yes, sir. As part of your investigation, did you make any determination whether or not there was a response by
Objection, hearsay.
any other agency to this package that was sent to Miss Benefield?
Objection, hearsay.
I'd allow that one. Judge?
Sustained.
Oh.
Did you tell Mr. Benefield that you would be able to unfound the case if he sent you the receipt?
Hearsay.
I'm asking him if he told Mr. Benefield.
Can you please approach?
Did you tell Mr. Benefield?
Can you please approach? Can you please approach the bench?
Sorry.
Y'all get up here, says the judge. Y'all come on right up here. We're up to 115 objections just flying through right now. I think Weather Watch points this out. This package, okay, so we heard a little bit about the package through with Stephanie Murphy, the attorney. But right at, like, just before the judge had entered an order, actually signed the order that there should be no contact between the two of them, Doug Benefield sent a package to Ashley Benefield. That package had a tea set in it. Yeah, I believe it was for her birthday. There might be some claims that this is getting to the poisoning, the heavy metals, like if there was like lead paint or something used on the tea set. I think that's where they're trying to build the poisoning claim at. But let's see if Mr. Taylor can figure out how to ask questions that aren't calling for hearsay here. Judge just giving a little lawyer 101 school right now. Bodie, a lot of states would have 12 jurors. In Florida, they have 6 for this particular crime. Do we need hazmat tea set on the thumbnail? I think we do, Red Pen. I think it's the judge like, did you say hazmat? I would have allowed that. I think the follow-up question where he said, in your investigation, were you able to determine if any other agencies responded to this call? That's a good question. That's a good question. And yes, it would have been hazmat. It would have been the same thing the state didn't want in before. But I think the way he asked the question would have got him that answer. And I wouldn't have sided. I don't side with the judge on that, sustaining that objection. It wasn't hearsay for sure. Yeah. Hazmat is hazardous materials, by the way. If you have like a semi-truck carrying a lot of a corrosive chemical that crashes on the freeway, they would respond.
I think the last question I asked you was, did you tell Douglas Benefield you could unfound the case if he sent you the receipt for the sending of this package of tea?
No.
So did you write a supplemental report as a result of this interview with Mr. Benefield?
Yes.
And this would have been on June 5th of 2018.
That's correct.
Now, did you put and document in that report anything about Miss Benefield?
I would have to look. If you don't mind, I can certainly.
Please.
I'm going to ask Jules who the drummer is in court. We've got to know.
No, I don't see anything about Ms. Benefield in the supplement.
Okay, you did determine, though, that the package, once you got the receipt, you determined the date the package was sent.
Yes.
And that was on when?
November 27th, which is when the injunction was signed off on by the judge. It was the same day.
But you also determined that the hearing on the injunction was November 3rd, 2007.
That was the hearing, but the judge did not sign off on this until the 27th, which was the same day. So.
Right. But at the hearing, Mr. Benefield was present when the judge announced.
Yes, when he announced, but it was my understanding it's not in effect until the judge granted his signature on the 27th, which is the same day that Mr. Benefield sent out that T-set.
Okay. Who is the lead detective in this case?
For which case?
For the homicide case.
I'm not sure.
Is it Detective Warren?
I don't know.
Do you recall contacting Detective Warren on November 30th, 2020 at 7:47 a.m.?
I do remember contacting him. I'm not sure if that's the date, but yes, I did.
Okay. And do you now recall that Detective Warren is the lead homicide investigator?
I'm not sure if he was the lead. I know that he was at that scene, but I'm not sure if he's the lead investigator.
Okay, so you talked to Detective Warren on that day?
Yes.
All right. You then, 16 days later, Detective wrote another supplementary report, correct?
I'm not sure if it was 16 days later. I would have to.
Why don't you take a look and see if that report isn't 16 days following your contact with Detective Warren.
And when did you say I contacted Detective Warren?
You contacted Detective Warren on September 30th, 2020 at 7:47 a.m.
It's awfully precise.
Yes, I entered a supplement on October 15th of 2020.
Okay. Now, following your conversation with Detective Warren on that day, September 30th, 2020 at 7:47 a.m. in the morning, you write a third supplement, do you not?
Correct.
And it's dated October 15th, 2020.
That is correct.
16 days after speaking with Detective Warren.
That is correct.
In that supplement, you list, do you not, the details of what you described today about how Miss Benefield behaved.
That's correct.
So let's make sure we understand this now. This is 2.5 years following the discussion that you related to the ladies and gentlemen of the jury of Miss Benefield's response. 2.5 years later, you remember the details of the conversation.
Absolutely.
And exactly what she said. Quotes. You quote her.
Yes.
But you never mention one word of it in your supplement that you wrote on June 5th of 2018.
You are absolutely correct.
Now we get to the point of
it. Nothing further. Let me just check.
Check with Mr. O'Keefe, see if there's anything he missed. Seems like it took a long time getting to that final question. It could have been a lot quicker.
Okay, that's all. Thank you.
Redirect?
Why didn't you add that information to your supplement back in 2018?
In my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So at that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time.
Okay.
And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying that I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system. Not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats. But I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown, and there was just no reason for me to put that in my supplement that she was having this massive meltdown, because I wasn't going to buy into it.
And so after she murders Doug Benefield, you thought it was relevant, obviously.
I thought that was very relevant information that needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren, correct?
Yes.
Okay. Thank you. No further questions.
Did Detective Warren direct you to write this stuff?
Absolutely not. I wouldn't take orders from him to begin with.
Whoa.
And 2.5 years later, you remember that she said specific things. This will help me keep my baby if the judge sees you arrest him, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Okay, can you be released from the subpoena?
Yes.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, sir.
No, I'm sorry, Judge. Larson. Sorry.
Oh, not releasing him.
Detective Gillen. Hold on. Sir, you have not been released from your subpoena. The rule of sequestration has been invoked by the attorneys. That means that you cannot discuss with anyone your testimony here today, the questions that were asked of you. With the attorneys, parties, anyone else. You can't talk with other witnesses about their testimony or the questions that were asked of them. You can't watch any of the proceedings that may be online. You are still sequestered pursuant to your subpoena.
Yes, sir.
State.
State calls Detective Brian Moreland.
Another detective. We've got to have the ME here soon. How many witnesses today? We've had 1, 2, 3, 4, 5. This is number 6 of 8.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but
Yes, sir.
Hello, sir.
Hey, how are you,
As
sir?
the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right. And if you just speak in a loud, clear voice right at the microphone, it'll pick everything up.
Thank you, Your Honor.
Good afternoon.
Good afternoon.
Please state your name.
Detective Brian Moreland,
How do you spell both names?
BRIAN-MORELAND.
And we've had some testimony about a Judge Moreland. I just want to make it clear, is there any relation between you and Judge Moreland?
No, ma'am.
Okay. What is your employer?
Manatee County Sheriff's Office.
How long have you been there?
Since 2004.
What is your current position with them?
I'm a crimes against children detective.
How long have you done that job?
Since January 2011.
And crimes against children, is it known by an acronym?
CAC.
CAC. Okay. So if you hear CAC detective, that's what we're talking about.
That's correct.
All right. So you've worked in that capacity for several years. So you were working in that capacity between 2017, 2019?
Yes, ma'am.
Okay. What does the CAC unit investigate?
Any crime that involves a child, any crime against a child, I should say. Sexual abuse, physical abuse, malnourishment cases, things of that nature.
And we heard that your office, you share an office space with other departments?
Yes.
And what are those?
The domestic violence unit is also in our office.
Okay. And back then, 2017 through 19, there was another entity in there with you? The child protection services, were they in your?
Oh, I'm sorry. Yes, DCF was in there.
DCF. Okay. I apologize. The letters have changed over the years. So.
Obviously, yes.
All right. Did you do a lot of investigations alongside, specifically DCF or Child Protection Services, what I call it?
So being in a crimes against children unit, we often work very closely with other agencies, DCF especially. My job as a law enforcement agent is to investigate crimes, basically. The child protection investigators, their job is to protect the children and offer services when needed.
Okay. So they have different goals?
Correct.
All right. When there's an allegation of child abuse, just generally, what is the protocol? To who investigates, who gets the information? Like, how does that go?
Generally, a report will come through the abuse hotline. Law enforcement gets notified, and DCF or child protection investigator will get notified, assign the case, and go out. We usually do that in tandem. Okay. So we're all there at the same time, and like we said before, different goals.
Different goals, but you're there at the same time,
That's
typically?
Correct.
Okay. And sometimes reports can come in, someone can just walk into the station, correct?
Oh, yeah.
Or call or do something like that with the sheriff's
And
office.
if we get it first, then that deputy or whoever's writing that report can contact the abuse hotline.
Okay. So I want to talk about, well, first let me ask you about Detective Gillum. So you said you're with the domestic violence unit.
That's right.
Do you know Detective Gillum?
I do.
Have you worked side by side or at least in the same space?
We've worked in the same office for many years, yes.
Okay. And he just testified about a phone call that he had that he remembers quite well.
Yes.
Do you recall him having a interesting phone call?
I remember the phone call. Yes.
Okay. Were you sitting there?
We shared a cubicle wall, so we couldn't actually physically see each other, but we could hear, obviously, everything that was going on.
Okay. And did this seem like a typical phone call that he...
He seemed quite exasperated at the end of that phone call.
Okay. At the time, did you know who Ashley Benefield was?
Yes.
Did you later become involved with Ashley Benefield with reference to CAC?
Yes.
Okay. And around December 2019, were there several investigations that came in, started a series of several investigations that came into your department?
Yes.
Okay. So I want to ask you about the first report or the first investigation.
Mm-hmm.
About when was that?
Can I refer to my report?
Sure. Go right ahead.
December 10th, 2019.
Okay. And generally speaking, what was the complaint?
Judge, based on prior motions and we...
Yes, sir. I understand. Go ahead.
Thanks, sir. This investigation involved allegations of sexual abuse.
Okay. So sexual abuse, obviously, of a child.
Yes, ma'am.
And who was the child?
Emerson Canny.
And who was the complaint against?
Douglas Benefield.
Objection. Oh, I'm sorry, withdrawn.
Is it the same objection?
No, withdrawn.
Go ahead, ma'am.
So, did you get assigned to the
He
case?
just objected. He's like, oh, wait,
Right. And
it was against
so-
Douglas? Yeah, let that one in.
Just as a matter of procedure, when you initially, when Manatee County Sheriff's Office gets a case, you're not initially assigned right away, right?
No.
What happens before you get
Generally what happens in cases like this is however we receive the report, whether it be through the hotline, whether it gets reported directly to the sheriff's office, a uniformed deputy along with a child protection investigator will go out to the scene. The uniformed officer will normally write the information down in a report, and that information gets filtered through our supervision, and if it needs to be assigned, it's assigned.
Okay. So theoretically, on this particular complaint, there had been some work done before you got it?
That's correct.
Okay. And then did you continue that investigation?
Yes, ma'am.
And as part of that investigation, was Emerson sent to the child protection team?
Yes, ma'am.
And what is the child protection team?
The Child Protection Team is a state-funded team that, for
Same objection, Your Honor.
Sustained.
Okay.
For my criminal investigations. Oh, I'm sorry. Sustained.
Next question.
Okay. Did you talk to Douglas Benefield?
Yes, ma'am.
Okay. Did you also speak to Ashley Benefield?
I don't recall if I spoke with Ashley on that particular case. I believe she was interviewed already.
Okay. And what did you do with the case? Were any charges filed?
No, ma'am.
Okay.
Megasaurus X, thanks for the great, kind words.
So I want to talk to you
Congratulations on
about
10
the
months.
second report, and that was what date?
Report date was March 21st, 2020.
Okay.
March 21st.
2020.
Generally speaking, what was that allegation?
That was a physical abuse allegation.
Okay. Physical abuse against?
Douglas Benefield.
And the victim of that would have been?
Emerson.
Okay, same parties. Mm-hmm. And how old was Emerson at the time, approximately?
2 years old.
Okay. And again, the same question, had some things been done before you got the case?
Yes, ma'am.
All right. Did you continue that investigation?
I did.
And at some point, did a second complaint come in before you were finished?
On the 23rd of, so March 23rd, 2020, yes.
Okay, so a couple days later.
Mm-hmm.
And what was this complaint?
It was, again, physical abuse.
Different than what came in a few days before?
Yes.
Okay. Did you investigate those two things together?
I put them in the same report, yes.
Okay.
Still your heart, Susan B. Thank you very much.
And
18 months.
what did
OG.
you do with those cases?
No charges were filed.
And I'd like to talk to you about the third report. When did that come to MSO, or when did you get it?
April 5th, 2020.
Okay. And generally speaking, what was that allegation?
Physical abuse.
Of Emerson?
Yeah.
And by Doug Benefield?
Yes.
And once again, before it was over, did you get another complaint?
On the 27th, another deputy responded.
Okay. And what was that complaint?
Again, physical abuse.
Same parties?
Yes.
Did you again investigate those two case numbers together?
Yes.
And what did you do with those cases?
No charges were filed.
We're getting a pattern here. Allegations,
At some
investigation,
point,
no charges.
Were you a part of what's called a staffing?
Donna E.
Yes.
That's terrible.
And what is a staffing?
Staffing is when the entities, as I mentioned before, come together and try to find a good way, or moving forward, a good way to protect the child.
Okay. And did you attend a staffing on this particular case?
The plethora of
The
cases,
Benefield,
yes.
yes. And as a result of that, were Ashley and Doug assigned to go to therapy with Dr. Broder, or not therapy, an evaluation with Dr. Broder?
Yes, ma'am.
Okay. Thank you. No further questions.
That was good testimony for the state.
Cross.
Just solid, factual. Malibu Surfer, welcome. Do you say plethora or plethora?
Just a few questions for you, Detective Moore. The cases that you referred to, I think you said there were 5 of them.
Yes, sir.
I don't want any details.
Okay.
Those cases have to be reported, correct?
Yes.
That's how they're initiated.
That's correct.
And would it be safe to say that in this case, the reporters, without any names, the reporters were...
Objection calls for hearsay.
Go ahead, finish your question.
Reporters were not all the same.
That I wouldn't know. I'd have to go look.
Do you have the reports with you?
I do have the reports with me. I don't know if it's going to tell me who the reporter was. Whether
clicking something over here. If you are, please stop.
I don't. Go ahead. I don't want to know names.
Okay.
Someone's clicking.
The names are confidential, are they not?
That's correct.
Okay.
Yes.
No clicks.
I just merely want you to tell us whether or not, in fact, the reporters were different individuals. Would you search your file?
I can look. I don't think the reports are going to tell me, but
Judge already checked the hearsay.
Right now, the question is just
whether the reports were from different individuals.
Whoa. Fall, notice there were some people in gray just gifted 20 memberships. Thank you, Fall. Jennifer Levy, you just got one. Jennifer, they got you. Fall, good job. Fall, thank you, my friend. Very generous of you.
so it appears the report on 12/10/2019.
I just want to, because we're in a bit of a delicate area, Detective, I just want to establish whether or not, if in reviewing your reports, you're able to tell us if the reports were initiated by different individuals.
By looking at my reports, I cannot tell you that indefinitely.
Did you at any time personally interview Ashley Benefield?
Honestly, I may have. I don't recall if I ever interviewed Ashley. I know I interviewed Douglas quite often. Initially, when I get these cases, the interviews with her were already completed. So.
Did you at any time personally interview the child?
No.
That's all, Your Honor. Thank you.
Redirect.
I believe you said, with respect to did you interview Ashley, that you said by the time it gets to you, a lot of times those interviews have been done.
That's correct.
And that would be by who?
Uniform.
Uniform. Mm-hmm. And then he asked, did you interview the child? Do you normally interview children?
No.
What is the protocol for children?
Forensic interviews are done by child protection team.
Okay. And so generally speaking, you wouldn't say you interviewed children?
No.
And was this child of an age to be interviewed anyway?
No.
Okay. No further questions.
Sir?
That's all.
Can this witness be released?
I'm sorry.
Can this witness
Yes.
be released?
Sorry.
Mr. Taylor, can this witness be released?
Yes.
Sir, you're hereby released from your subpoena. You're free to go. Thank you. Thank you. All right, members of the jury, we came back early. We went to an early lunch, so we got back a little bit early. Now I think a good time to take our mid-afternoon break. It is about 2:50. So how about if we take, we'll probably end up being about 15 or 20 minutes.
What was the one thing you got from this last witness?
You were free to use your phones. If you need to send and receive text or email or phone calls, just don't talk with anybody about the case amongst yourselves or anyone else. But of course, as we discussed, don't do any research on the people, places, things, or legal topics you've heard anything about. Stretch those legs, and we'll see you back in a little bit.
Five allegations of abuse. Is that what stood out for you, Judy?
All right. Jury's out. You can have a seat. Stay looking at the list in front of me. 1, 2, 3, 4, 5 more.
Total witnesses.
Yes. Okay. Yes. Yes. Okay. I have a question about that.
Yes.
So we've had Dr. Vega kind of on hold, and so I don't know how far we'll get with these next 3 witnesses. I can have him come here, but my question would be is if it was going to take us past 5, if he comes, can we still do it? Because he's very busy, and I hate to take up so much of his time. Or would Your Honor rather, because I know you wanted to deal with some other things, would you rather me tell him first thing in the morning? I know you don't know how long these witnesses are going to come. Take.
I can tell the court that Dr. Broder is going to be up there for a while.
And so I just don't, my question is, if I have him come, can we deal with him today? Or do you think once we hit 5 o'clock, if it's before him, you're going to want to go home? Which I understand either way.
Yeah, I would imagine that if it starts pushing 5 o'clock, we'll probably break and start again tomorrow.
Yes, sir. Okay. Okay. That's the schedule. That's all I had.
Okay.
I do have something else, if you don't mind. Not as scheduling. So the clerk was kind enough to unseal your order, but the items that were attached are evidently in that room locked up. And so I just don't know how we could get a copy because I haven't seen them. And so I just want to address it with the court of how to get a copy.
The order's unsealed, but the items are still locked up.
The evidence clerk is making copies.
Oh, good. Perfect. Thank you. Thank you, Judge.
All right, anything before the break?
No.
Break.
Yes.
All right, so now we're going to break, I think. Yep. Let's see. Jules has her phone out. I think she's going to be calling us. We'll keep the phone open for her in case she does. Just waiting for people to file out of court. You do see a lot of the purple that you mentioned, a couple people in purple. Two sides seem cordial. Is that a rain jacket? That looks very warm. Those typically don't breathe very well. Do you think Sarah Boone's help wanted ad is above their copier? Probably is.
Call from Jules.
Hello, Jules. We saw you just were leaving the courtroom. What do you have for us here?
Well, I'm kind of perplexed. So if you could be specific with questions, I'll be more than happy to answer them.
The last witness, Detective Brian Moreland, talked about 5 different allegations, various types of abuse allegations that Ashley had filed against Doug. Everyone was investigated, and nothing happened. There were no charges. The detective before him recounted a phone call that he had with Ashley, where she demanded that he arrest Ashley, or sorry, that he arrest Doug in court when they show up for their civil court, because she thought, or he said that she wanted that would help her keep her child, prevent him
And I
from
can
getting some
tell
custody.
you,
Yeah.
and I could tell you that when they got spoken about, remember this morning when I told you about there were 2 female jurors, these 2 particular female jurors sit in the front row. None of the jurors communicate with each other. Like I told you, there is nothing, okay, between any of them.
Yeah.
During that particular testimony that you just spoke about, that lit a fire under them. And they were nodding. That's when the note-taking started. Well, actually, the note-taking actually started with, with him, with Gillum. That's when the note-taking started.
He seems pretty trustworthy. I mean, he has a sharp memory for something years ago that he didn't put in his report. That was pulled out in the cross-examination. But he's like, look, I'm an officer. She called me. I had these other 2 cops there. They can vouch for it. But she was sort of abusive, a little manipulative. There's a word I'm trying to say.
Well,
manipulative.
Manipulative,
There it is. On the phone.
Yes. Well, prior to the detectives taking the stand, as I said, this jury is extremely hard to read, okay? It could, in my opinion, these people could go either way. After this, I think Mr. Taylor lost the jury. If he had anyone, he lost them. Just by the body language, especially of these 2 women. So,
That's interesting because here in the next, 12 hours of court time, we're going to have the ME, and the state's going to basically rest their case. And if they've lost the jury here, that's going to be a nail in the coffin, I think.
Because there's going to be the question, I'm sure, I would think that the prosecutor is going to, once the ME comes on, there's going to be that question in regards to the testimony yesterday when that officer said that Doug was cool to the touch.
Yeah, that's going to be very important when we hear that, because that tells us if she was lying from the get-go.
Yes.
Still could be telling the truth. And this is everyone's just perceptions of how they've dealt with her. But everyone's asking, who was the judge saying who's clicking? Was that you, Jules? Were you clicking?
No, it wasn't me. No, I have the pen that Rob made for me, and
it's
not a clicker. They don't click.
I have one as well.
It wasn't me. It was someone in the row in front of me. Not in the row in front of me, but it was the guy that's sitting behind the big guy. That's who it was.
Who's drumming on the table? Can we hear the people drumming? That somebody's going.
I have no. I don't know who. Okay. I don't know who it is.
I think that's an attorney.
It could be. I don't know because I can't hear. I didn't hear it. What do you call it? The jury was not happy with the attorney Miss Murphy.
Stephanie Murphy.
With Miss Murphy.
That was probably the highlight of the day for me. I loved that exchange, but what didn't they like about her?
I don't think they were buying into everything that she was saying. It was more like shaking. One of them was like shaking their head a little bit. They were not taking notes. It was almost like it appeared like they were watching a tennis match. They look at the lawyer, then look at her, look at the lawyer, look at her. I mean,
they show up for court and they got a show. That's what happens. That battle back and forth, it seemed personal. It seemed petty. I think the state was right when they said that it seems that the defense is just trying to get in those negative admissions by Doug in that civil suit. I think that was their end goal there, not so much as to impeach the witness, although they take that as a side benefit. But I think they wanted to get his admitting that he shot the hole in the ceiling and punched a hole in the wall and hit the dog. Those would be strong statements to have out in front of the jury, but I don't think. I think the judge was right in not allowing that, even though I think that the questions he was
I respectfully disagree. I think it should be let in. Okay, but that's if I had talked to you an hour ago. I would have argued and debated with you on it. I still kind of feel that way, but after hearing these detectives, especially Gillum, I took a major shift.
Yeah. Interesting. We don't know what she's going to put on as far as her defense. She doesn't have to do anything. They don't have the burden of proof. I don't believe. I mean, even in Florida, self-defense is something the state has to prove that it's not. So.
But Mr. Taylor is trying to get in an expert on battered spouse syndrome. Okay, the law here in Florida has changed when it comes to expert testimony for battered spouse syndrome. This is why the decision hasn't been made yet by the judge if their expert witness can testify, because, quite frankly, I'll see if I can pull up the new requirements and send and email it to you. Okay. Obviously, I can't do it now. In my opinion, she doesn't meet the requirements at all. She doesn't even come close to meeting the requirements. So I don't think this judge is going to allow that expert to testify. I could be wrong. What do I know?
Interesting. This might have implications for Sarah Boone's case as well.
Yeah, she has no choice. She's going to have to get on that stand and testify. If she doesn't, she's definitely lost.
Isn't it true that she didn't take...
If she does...
Sorry, isn't it true that she did not take the stand in her own, in her self-defense
That's correct. She did not.
How in the world can you expect to win a self-defense hearing if you don't put your story out there?
She did not. She hasn't spoken a word to anyone since she shot him. You know what also is I found very interesting? I told you Doug Benefield's daughter, Eva, is here, as well as his cousin who testified.
Tommy, yep.
Okay. And they are not sitting together in court at all. And the weird thing is even right now, out in the hall, she is with her friends. He is nowhere. I mean, there's no interaction between her and her uncle. I find that really odd.
I did notice they were sitting on different rows on the first day. She was sitting in front, and he was like a row back. I thought he had his wife with him the first day, or somebody that was sitting very close to him. I assume it was his wife. It did look like she was somewhat younger.
There's no woman with him today.
Okay.
but they don't have any interaction whatsoever. And I just kind of find that really odd.
Sounds like me and my cousins. So I don't.
But this is a cousin who knew absolutely everything about their relationship.
It does seem strange because he was close to Doug at a time when Ashley was present in Doug's life. And then for Doug to pass away, and then for that relationship, for him to just disappear out of their life, that does seem a little strange. But
I just, I just find it like really weird.
Fairchair nailed it here. Families are complicated. They are. There could be a billion different reasons. And it might just be that she has a huge friend support, that she has a great support group around her in this. And I hope she does, honestly. You always feel bad for the victim, the person who died. It's rarely did the person die deserve it. Right? In a murder case, it's always terrible, but the family they leave behind her, who our heart aches for, and she's really one of the main victims here in this case as well. So I hope she's doing well.
And the other, she does have a lot of people with her today. But my other thing, and I doubt that you would be able to answer this, so I'm going to have to reach out to Rob or Melanie or somebody. I need a lawyer.
I know a guy.
And the reason why I'm questioning this is with Ms. Murphy taking the stand and discussing her client relationship with Doug, I find is really weird and strange. And the reason why I bring this up is approximately a year and a half ago, I interviewed Matt Luca, who was the attorney representing attorney Stephen Bertolino, who represented Brian Laundrie. And I attended that hearing, and he won. He lost and won. He lost in the respect of he could not get the civil suit dismissed against Stephen Bertolino, but he won that Stephen Bertolino would not have to testify because Brian Laundrie was deceased. And even though Brian Laundrie was deceased, he still does not have to talk.
Right.
So
the question is that something the lawyer can choose? Can say, I'm choose to divulge this, or I have not been released by my client. My client's passed away, so I'll never be able to say what we had. Or do they hold that confidence?
This is why we need a lawyer. We need a lawyer to answer this question.
Yeah, interesting. I wonder if it's a state. Maybe Eva authorized the releasing the lawyer from that attorney-client privilege. I wonder if it went down like that. But
I don't know. But
it looks like a lawyer is probably going to cover this. So Peter Tragos is probably going to cover that this afternoon. He's doing recaps on this case and does a great job.
Yeah, but I'm here in court, and then it's going to take me an hour and a half to get home. So if anybody is in there, they need to ask, because if anybody's going to be in his chat, then I think that this is a really important question that needs to be answered, because how did she get away with this?
Yeah. You could look at that and say that's unethical for her to do that, but I don't have all the information as to what went into this decision if she was released.
Me either.
There may have been a standing thing with her client that if I ever die in some weird way, I release you from. They could have had a lawyer prenup. So
I don't know.
All right.
Okay.
I'm going to let you back in.
When because we're going back in. I will call you when after court.
Sounds great.
Tonight,
thank you very much,
at
Joyce.
5.
Appreciate what you do.
Love you guys. Bye.
Bye. All right. Jules is our eyes in court. She's actually seated just a row or two back behind Miss Benefield. Does a great job following that. I'm glad to know that she was not the clicker. That is good. She's really good. She understands court decorum and follows the rules very well. It could be next of kin, power of attorney type situation. Let's see. Peter Tragos is going to do a 6 p.m. on this. That would be great. Can't wait for him to hit some of these highlights. There's a lot for him to talk about. And this is his neck of the woods. So honestly, I like a lot of different lawyers' takes on the events of the day. But Peter Tragos operates in court. He's licensed. He practices in Florida. And sometimes there are nuances to a case and to happenings of the case that are specific to that state. So it's always great to have somebody who's on the inside who understands what's happening. Jen Devka says, well, would you look at me growing up? 6 months, Jen. I get the yellow courthouse. Thank you so much for being awesome and welcoming me with open arms. Love it. And all the emojis. Thank you, Jen. Welcome. Let's see. Yes, your courthouse is yellow. That happens right at 6 months. All right. Some of you, I've seen this a couple times, that people get some Amber Heard vibes from Ashley. And really, as we sit here as members of the jury would, we get to observe things and determine, the truthfulness in what we believe. There's nothing that the jury should observe from her behavior in court that they should take as into their decision unless she testifies. And that's something they should consider. But only the testimony that comes across in court, which unfortunately for Ashley's case has been somewhat harmful, especially today. Some information about her behavior, interactions with other people, including law enforcement, that seems just a little bit off. And that's not going to help. So the defense has a big uphill to climb here when they pick up their case. Probably tomorrow morning, probably around 10 o'clock or so. Quick recap for night. Let me see if we can pull that up for you. Just for today, day 2, we started with Alicia Byers. That is Ashley's mom, took the stand, gripping from the get-go. She did not want to be there. She was nervous. She was scared. She was subpoenaed by the state, had to testify against her daughter. But really the questions, there wasn't anything there. There was really nothing that the state got. We found out that she left to take her granddaughter to the park at 5 o'clock. That's the same time Doug arrived and the same time the U-Haul arrived. That's pretty much all we got from her. And then the state kept her subpoena, so she can't be in the courtroom. I think I would say that was a psychological sort of like a jerk move to do to keep the defendant's mom out of the courtroom, because now under the sequestration rule, she can't be there to watch the trial or to be there to support her daughter. That was the first thing. Alicia, Bug Duggar says, Alicia, Discord, Welsh Lady reads, hey, I see you. Bug Duggar, thank you very much. Next witness, Barbara Russell. She's the interesting, a therapist situation where she was treating or seeing in a clinical setting, Ashley Benefield, and then Ashley didn't have anywhere to live and came and lived with her for 8 months. I'm like, what? Yeah, it was a little strange there, but that happened. That was pretty quick. She also had a bias was very visible. She hated the state and loved the defense, even with gushy big smiles and compliments in the 1 or 2 questions that she answered for defense on cross. Interesting there. Number 3 today, Lieutenant Dan Dickerman. He was the homicide investigator. He got there between 7:30 and 8 p.m. The crime scene had been cleaned up. He testified about Ashley not getting arrested till November instead of September. He said, confirmed the U-Haul truck was there. Not a lot there. The scene was the body had been moved, so the blood smears were visible on the ground and everything. Stephanie Murphy. This is where the fireworks just exploded today. Stephanie Murphy was Doug's lawyer. And his lawyer that was handling the child custody issues, family law. And she has all the receipts and all the details. She's a very sharp lawyer, just a witty, quick, smart, you name it. It was a battle of wits between her and the defense, and it was crazy. It was awesome. I want to go back and just rewatch that one, the whole exchange from start to finish. It was amazing. Let's see. She was the one that was wearing the fuchsia dress, held her own very much. Even so, I think at the very end, the state stopped objecting because they knew that she could handle it and possibly handle it and get a jab back at him that they could not do on their own. So that was really cool to see if you like courtroom drama. And then we had 2 detectives, Chris Gillum and Brian Moreland. Chris Gillum talked about the phone call that Ashley had where she said, I want you to arrest Doug in court in front of the judge. That'll help me in my case, keeping my child. She used a couple swear words with him, some crying, some screeching is what he said, trying to get him to do what she wanted, which was arrest Doug in court in front of the judge. He said no, he wouldn't do that. She hung up on him. Detective Moreland talked about the abuse allegations. There were multiple abuse allegations filed by Ashley against Doug of various natures involving their daughter. They were investigated because he is a crimes against children investigator. They were investigated, and there was apparently nothing found, and so nothing happened, which it just goes to say that from the legal perspective, they think that those were unfounded allegations. Let's see. Alyssa, member for 7 months. Love this community so much. Feels like my family. Thank you. Nan R, member for 9 months. Abuse takes many forms. Please be kind to impossible. I have a friend who wasn't believed. Years later, he admitted to abusing her. Very true. Very true. And we mentioned this briefly in passing, that a lot of us have experience or know people who have experience in this, sadly, in this area. And it is very, very different. What one person experiences as abuse might be very different on the scale and on the type of what someone else experiences. One might be very visible and one is invisible, but it doesn't mean that the one is abuse and the other one is not. In this case, the allegations that Ashley made appeared to be unfounded, which I think the type that she was making would show some sort of evidence, which they were not able to find. So I think we can safely assume that, at least from a legal perspective, there was not enough there to do anything with, if there was any. But thank you for the reminder. I appreciate that. Let's see. Rob would be a good one to ask. He's a family law lawyer. Yes, he's going to have some good information on this as well. We're coming back to court right now. A lot of noise.
All right, we're back on the record.
Here we go. Right, just in time.
Ready?
Yes.
Fitz? Yes.
Michelle Shelby.
Right. So we'll bring in the jury.
You will bring the jury.
Welcome to the gallery. You can see there's Jules sitting there in white, just over the defendant's right shoulder. Mental abuse is abuse, very much so. And it's just as terrible, just as terrible. It scars the same way. It hurts. It cuts just as deep. It is terrible. And it could have been both directions.
The transcripts for the hearing in the Hammer hearing, is that what you were? I did, but I haven't.
Jury's coming in. This is our last segment of court. We've got about an hour and a half-ish, I think, of court left.
You all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves? Talk with anybody outside the jury about anything about the case? Or do any research on people, places, things, or legal topics you bring on back?
No, sir.
Everybody says no. We'll call your next witness. The state.
State holds Dr. Brad Broder.
I heard Dr. Brad Broder.
Please face the clerk. Raise your right hand. You sworn in?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
This deputy is a giant of a man. Look how tall he is.
Good afternoon, Judge.
My name is Joe White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. You want to be about 12 to 15 inches from the microphone, so you can probably scoot up just a little bit. Adjust this left, right, up, down. And just speak in a loud, clear voice. It should pick up everything for you, breathing, and hunger.
Fair enough.
Bless you.
Good afternoon.
What's that pin he's
Good
wearing?
afternoon.
What's the...
Judge, just for the record, we renew all prior objections.
Yes, sir. Overruled.
Please state your name.
Brad Stephen Broder,
How do you spell your last name?
Broeder.
What is your profession?
I'm a psychologist, clinical psychologist, licensed here in the state of Florida and in New York State.
And how long have you been a clinical psychologist?
I got my PhD in clinical psychology back in December of 1986.
And when did you move to Florida? I think you said New York? You were in New York before.
Correct. I first practiced in New York and relocated here in the summer of 96. I was licensed here by February of 1997 and have been practicing here ever since.
Okay. And do you have your own private practice?
Exactly. I'm a solo practitioner.
Okay. Do you also do some, what I would call consulting work for the Child Protection Team or Child Protective Services?
Yes, I've been a consulting psychologist to the Sarasota County Child Protection Team since the summer of 1999, and several years later was hired as a consulting psychologist by Manatee Children's Services, which is their name for their child protection team. Pardon me. And recently have been contracted with the Fort Myers Child Protection Team. That's just as of this summer.
Okay. And can you just briefly explain what are your duties with reference to being a contractor for the Child Protection Team? What do you generally do?
Well, through the Department of Health, each county in the state of Florida is supposed to have a consulting psychologist on their team, and that is for several reasons. One, it helps out with supervisory cases if on an as-needed basis, as well as once or twice a year there's supposed to be in-service trainings where you conduct seminars, do presentations to help the staff there. But primarily it's to attend the multidisciplinary staffings, which they're asking the consultant to come in and discuss, you know, a certain case, what might be going on, if you have any kind of impressions or recommendations. Based upon those kind of meetings, then sometimes the psychologist myself would be asked to conduct an evaluation.
Okay. And ultimately, were you asked to conduct an evaluation of Doug and Ashley and Emerson Benefield?
I was specifically asked to conduct psychological evaluations on each of the parents, both Doug and Ashley, but not their child, Emerson.
Okay. The child was pretty young, correct?
2 years, 4 months to be exact, during the time I did the evaluation in the summer of 2020.
Okay. So you started the evaluation about when? You said summer, but...
I believe it was June 1st to be exact when I first met Ashley, and the next day I had met Doug for the initial intake interviews.
Okay. And what was the general goal of these interviews? You eventually were going to report back, I would assume, to the entity that hired you?
Yes, each psychological evaluation is meant to be submitting a report with diagnostic impressions and recommendations based upon the data that's been collected. The evaluation is based upon whatever the CPT recommendation was, meaning referral for the recommended evaluation. In this case, Manatee Children's Services had specific questions about each parent.
Okay. So, and your evaluation is generally focused toward the best interest of the child. Would that be a correct statement?
Yes, absolutely.
Okay. So you said you first began this around June 1st of 2020?
That's correct.
Did you ultimately complete evaluations of Doug Benefield and Ashley Benefield?
Yes, I did.
Okay. And as part of this evaluation process, did you review documents?
There's a series of steps in any thorough psychological evaluation, which includes collateral data, which is both defined as interviewing other people as well as reviewing documents, yes.
Okay. And did you do that? You reviewed documents?
If I may, I just brought the reports along with me in case I had to refer to them. But yeah, there was a series of documents reviewed for each of them.
Okay, and we don't need to get into specifics about what the documents were, but you did review several documents for each of them.
I certainly did, yes.
Okay. And what is a collateral interview?
That's when I ask each person to give me a couple names of people that they think understands their situation best that I could contact and call and just do kind of a phone interview. if possible, obviously a face-to-face interview is preferable, but based upon where people are situated and located, sometimes it's just easier to have that telephone conversation. So there are certain people, like the people through Manatee Children's Services, that I was going to be speaking to, for example, Kimberly Griffin, who is the case coordinator. But in addition to that, I asked both Ashley and Doug for their own people that they'd want me to speak to. But then, of course, doing the evaluation, I have the kind of wherewithal based upon what I learned from them if there are other people I need to speak to or that I believe I should speak to in order to get a more complete picture of the individual.
Okay. And did you, in fact, do that with reference to both of them? Speak to collateral contact?
Yes, I did. Yes.
Okay. Did you meet with Doug and Ashley and Emerson together or separate?
Given the structure of their family unit, I had multiple interviews with each of them individually. I had several interviews with them together, a couple of interviews with them together as the couple, but several additional interviews with them when they would exchange Emerson at my office, and when we would, kind of see how that the drop off or the exchange goes. But I had also seen each parent with the child both in their residence as well as in my office. So there were multiple interviews.
Okay. So this sounds pretty extensive. So how much time did it go on over?
Throughout the summer of 2020. I think the report was actually completed and submitted on September 14th of 2020.
So I want to speak with you about Ashley specifically. Did she ever show any hesitation about meeting you with Doug present?
No.
Okay. Did she act differently when she was with Doug meeting you as opposed to when she was not with Doug meeting with you?
As I had indicated or described in my report, she did demonstrate or present with a different demeanor when seen together versus when I would just see her individually.
Okay. And when you saw the two of them together, did they discuss the plans for going forward? And I'm talking about moving. So did they discuss that with you?
Ashley had made it very clear that she had every intention and desire to relocate back to her home state of Maryland. Doug had the impression that this was something that he too could do because he had some connections through the Defense Department and some of the work that he did. He felt he'd have more clients up there, so he was perceiving that as he shared with me, a fresh start that they could reconcile and be together in Maryland.
And when Ashley and Doug met with you together, did Ashley indicate that this was the plan, that they were moving all together as a group?
Ashley had no intention of moving together as a group. She had every intention of moving with her mother and Emerson and becoming situated in her grandmother had passed away and the mother had inherited the house, so they had their residence established. So she had that plan.
Okay. And so I guess I wasn't being very clear. Were they moving their items together, like same U-Haul truck?
No, absolutely not.
Okay. So Ashley never told you about that?
Quite to the contrary, she made it clear that she did not want him to move in, regardless of what he thought or whatever he was planning. That was not part of the plan.
Okay. And when she was alone, she would indicate to you those things that you just described? Or did she indicate that when she was with Doug?
When she was with me during our individual meetings.
Okay. When she was with Doug, how was her demeanor? How was her attitude about those issues?
She would basically respond in a very deferential way. She would let him say what he wanted to say, but my focus was not so much on what their future plans were. It was, they weren't even officially divorced. My focus was, again, getting back to the point about the best interest of the child. The child protection team is, how do we get this family out of this stressful situation and then create something that's going to be better for Emerson?
Okay. Did Doug, during your joint sessions, did Doug express in front of Ashley that his hopes that moving forward this was going to be an attempt at reconciliation? Did he express that in front of Ashley?
Yes, he did.
Okay. Did Ashley ever correct him and say, whoa, wait a minute. No, we're not doing that?
Not really. I think the closest she ever got to that was to kind of say, well, just kind of slow it down and, we'll talk about that later. And that's, that kind of thing. She would kind of deflect attention away from that.
Okay. And did she ever say in one of her individual sessions with you, did she ever say anything to you about she was running out of time and needed to move to Maryland or something like that? Do you recall?
Yes, we had that discussion in one of the sessions.
And can you just explain what she said about that?
In essence, she was very frustrated and concerned that...
I'm not going to object to, as I understand that he's called as a fact witness, and he's giving opinions.
Okay, you can answer the question. What was it that she said about the issue of running out of time and wanting to move to Maryland?
She was openly sharing with me her utter frustration with the sheriff's office, with CPT, with the court system, indirectly with myself, although she had also complimented me by thanking me for doing a quote-unquote thorough job. But who was going to look out for Emerson, who was going to help Emerson, and she needed to do something. She needed this to be over with so she could get on with her life. She used the phrase, "My life is in a shambles."
Okay. And did she make any statements to you about why she needed this to be over so quickly? Or why was it, did she feel it was taking too long? I guess should be my question.
She certainly felt it took too long, and she just wanted to get on with her life.
Okay. Did she admit to you that she was, in fact, going to marriage counseling with Doug?
She had been in agreement with them starting with a second marriage counselor, Dr. Quintel, after their attempts at marriage counseling with Sharon Foster had not worked out.
Okay. So she indicated that their intent to go to Dr. Quintel, but during the same time, was she still saying they would not reconcile, or she was saying they did want to reconcile?
I don't think she ever used the word reconcile when with Doug. She clearly made it very clear to me that she had no intention of reconciling.
Okay. And during this time, I would say the year at least before your meeting, did Ashley talk to you about doing things with Doug? And for instance, I'm talking about lunch and activities. Did she talk to you about that?
Throughout the time that I worked with them, it was very clear they were very open, sharing with me the things that they would do together, such as, for example, the hit movie that particular summer was the sci-fi thriller Tenet, T-E-N-E-T, and they had agreed to go see that so the grandma could watch Emerson. They have a quote-unquote date. They enjoyed the movie so much, but also found it kind of confusing and hard to follow that they agreed to see it a second time together and had a follow-up date for that movie.
The date was so
but
good,
in
we're
addition
going to
to that, they had done other things. She would go to Doug's apartment complex where they could use a community pool and take Emerson into the pool. They shared with me that they had gone to the beach. She described in detail watching Doug, I think it was Father's Day specifically in my notes there, where she described how nice it was to see Doug playing with Emerson, playing in the sand with Emerson. And so then from there they would go out to lunch or go out to dinner, sometimes with Emerson and the grandmother, sometimes without. So they were, throughout the time I was working with them, they were seeing each other.
Okay. Did Ashley ever talk to you about the birth certificate for Emerson?
Naturally, in this kind of evaluation, since it concerns a child, they talk about the child and the marriage and the relationship and see each parent with the child. So yeah, that came up. She gave birth at Tampa General Hospital and signed the birth certificate. Emerson Grace Caney.
And do you know whose name Caney is?
She wanted to keep her grandfather's family name, and so therefore she used that name.
Okay, so the child wasn't named Benefield?
Was not.
And did she ever put, or did she indicate to you whether she ever put Doug on the birth certificate as the father?
She did not. That became a point of contention for the two of them, things that they were discussing, changing the name from Emerson Grace Caney to Emerson Caney Benefield. That was an issue that they were discussing.
And did she ever admit to you that she didn't tell Doug that she was even giving birth?
She shared that she did not inform him.
Okay. And you mentioned a little while ago that she was frustrated with some of the agencies. I think you said law enforcement, the courts, that kind of a thing.
Hazmat.
Did she express why she was upset with them?
She felt that Doug was unfit to parent Emerson, that he was only using the child to get her back, to win her back, so to speak.
Okay. And these agencies, they played into that, or they didn't play into that?
What was described and came out of our discussions in the interview sessions was that she felt that no one was willing to step forward to protect Emerson, that they all got it wrong, for example. So when CPT evaluated the situation where she had bruising on the neck, she described to me that it was several days later, so the bruising didn't show up, and that went down as unsubstantiated, so it was never followed up on. And
okay, so she basically felt like they were getting it wrong. These agencies were getting it wrong.
No one was protecting Emerson. She did not agree with that.
During one of your last meetings with Ashley, did you have a conversation with her in your waiting room?
The day after, a day or two after the report was submitted on the 14th, Ashley showed up in my waiting room, unexpected, unannounced, and she wanted a copy of the report, and I had explained to her procedurally that the work product that I produce is then the property, in this case, of Manatee Children's Services, and had submitted to them. But I let her know that she'd be able to get a copy through her attorney, but they did have to get a court order to release it, and that's usually what happens. It's kind of a formality, but it's no longer something for me to share or divulge.
Okay. And did she have a reaction to that?
Her reaction was that she felt, again, very frustrated, thwarted in her efforts. She wanted to get on with her life, and she felt she needed to know what was going to be recommended so she could move on.
Okay. And during that conversation with her, did she say anything that that struck you as interesting during that conversation with her?
Well, she had explained previously and then repeated it then that once she was able to relocate to Maryland, she wanted to establish residence, as she had, in essence, researched it, knowing that if she had established residence for at least 6 months, she could then appeal to the authorities in Maryland to get relief and have Emerson, basically have full custody of Emerson and not that. So she had used the phrase during that conversation that she would take matters into her own hands.
Okay. And did she express to you at that time about being frustrated about the timing, things weren't going fast enough?
By that time, she was, again, ready to move on, and she was frustrated with the entire system.
Okay. And did she make any more statements to you at that time?
Not that I recall. Again, I tried to encourage her to be patient, that her attorney would definitely be able to get a copy of the report, and they could, work things out once they read the report, and they should be able to settle things.
Okay. And did she ever say what she would do if it wasn't fast enough?
No, I don't think she specified anything more than her desire to, again, get on with her life.
Okay. When was the last time that you saw Ashley? Was it that day that you're talking about?
When she came to the office unexpectedly, yes, that was the last time. Prior to that, the last time I actually saw them was, I saw Doug on September 7th, and then I believe I saw them together on the 10th of September.
Okay. And the last time that you saw them together, how did they seem? Did they seem the same as they had the times that you had seen them before?
Well, Doug, too, was becoming frustrated because he was viewing this as a fresh start, as I said.
Sustained.
Okay, I'll move on. Did you complete the report for Ashley Benefield?
Yes.
And how long was that report?
27 pages.
And did you do the same type of a report for Doug?
Yes.
And was it about the same length?
I think 24 pages.
Okay.
I'm sorry, 25 pages.
Okay. And I think you already explained this, but you turned your report over to CPT when?
September 14th.
September 14th. Okay. And then what happens to it after that is not in your hands.
It is. Sometimes I find out. Sometimes I get feedback. Sometimes I don't. It's the work product goes to, in this case, Manatee Children's Services. And
okay. And did any of your evaluation or contacts give you any concern for the safety of Ashley or her child going forward?
Their original marriage therapist, Sharon Forrest, had concerns. She certainly expressed concerns, yes.
Did you have any concerns? Well, let me ask you this. Did Ashley Benefield ever say to you that Doug physically harmed her?
No.
Okay. Did she present you to you as being fearful for her own safety at the time she was having sessions with you?
Her concern was all about the safety of Emerson, not about herself.
Okay. Thank you. No other questions?
Excuse me.
Cross.
They don't have to prove that she murdered him. That's a stipulation. They know that she shot him. They're admitting to that. They're just trying to prove
Give me just a moment, Your
whether
Honor.
it was justified or not. Defense thinks it was justified. The state says it was not. That's why we're going so much into the relationship.
Dr. Broder, good afternoon.
Good afternoon, sir.
We've met before.
Yes, sir.
Your history in this case has wound its way through to where we are today, and it's encompassed prior proceedings, has it not?
Yes.
Okay.
Yes.
And you've had occasion to sit for a deposition in this case?
Yes, correct.
And you've also given previous testimony?
Twice before in the dependency case.
Don't tell me where.
Okay.
So you've told us that Ashley would act one way when she was with you, but she would act differently when she was with Doug. Correct?
Yes, that's correct.
All right. And your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him, to kind of go along with him.
Yes, in your words, I believe in your report, go along, get along.
I believe that's correct.
Correct?
Yes.
And that would be especially the case when Emerson was involved.
Yes.
All right. So, for example, if she didn't particularly want to be in
Judge,
the...
I'm going to object. Can we approach, please?
Objection and approach. No speaking objection, so we're not sure exactly what's happening. I'm just taking a power nap, just a couple seconds at a time is all I'm doing. And then I clicked on the wrong part of the screen and that appeared. So that sort of outed me. This witness seems impartial, which was something we really like in a witness as far as credibility goes. Someone who is just as eager to answer the questions truthfully from defense as they are from the prosecution. And I love that in a witness. As a potential juror myself, that's something I'd look for. It goes to their credibility in a big way. I was busted. You guys caught me. I want to hear so he did the evaluation on Doug and Ashley. What was the main result? I mean, they're both sane. What was his finding at the end? Did I sleep through that? Chat has approved parental penguin naps for RA. Yeah, we are split. I think it's perfectly okay to be split here. The state's not done. It's weird because we're in a murder trial and we're not talking about the actual event, like the firearm. How we glanced over the injuries to the victim. That's not the focus here. We're all focused on the relationship itself. Sorry, the kids are watching Olympics in the other room. I think somebody just scored. So. It's a very different case. I like it. I like it a lot. I've really enjoyed a lot of the cases we followed out of Florida. I think part of that comes from the fact that Florida is a sunshine state, and we have access to a lot of the documents and openness in the motions hearings and things like that leading up to trial, which is good. Fun news in other relevant cases we're following while they have this break for a little bit longer. I believe we've got the motion in from Brian Koberger's team for a change of venue. We have a hearing coming up. Let's see, for BK, the change of venue hearing is said I had June 27th, but it can't be June because we've passed that. Is it July 27th? It's August 29th. We'll have to look at that. But obviously that's going to come up soon, and that's going to be I think it's going to be a full day hearing, which will probably air. If not on this channel, we'll air it on our Top Mark Media channel. There's no way he found them sane, says Kathy. These people had issues. Probably no more so than all the rest of us. I mean, maybe a little bit more so. Let's see. Michael says, I subscribed to Peacock TV today for the Olympics. I have soccer on one screen and you on the other. Thanks for the heads up about Peacock. Actually, I got a tip from chat. Someone volunteered and said, hey, I can put you on my account. I said, I appreciate the tip. I'll go ahead and just pay for my own account. I think if Peacock's providing the service, I should give them the money for it. I'm a big fan of paying companies for doing something I enjoy. So a few bucks for access to the Olympics for the kids to do that is great. Found Hussein. This witness did an evaluation on Doug and Ashley. I'm trying to figure out what his finding was. The Brian Koberger case, we want it moved to Boise. I agree. I also want it moved to Boise. I'll actually be up there at least for a week or so of my trip. I'll be up in Boise. Thanks, Samantha. The other channel I was talking about, where we run some of the court feeds for other trials, where we just provide just the court feed. Here's the problem. Courts like Brian Koberger's, they put the feed up on the internet, and then as soon as it's over, they delete it. We're a big fan of preserving that, and so we're going to bring that to you and preserve it on the Top Mark Media channel. We did that with the Chad Daybell case as well. We've done that with several of the Brian Koberger hearings, and we'll continue to do that going forward. So if you subscribe to Top Mark Media, you'll be able to access that. I rarely, if ever, provide commentary over any of those videos. Usually it's just a clean court feed. And some of the cases where we're going to be in person at the court case with our live view, putting out the signal from the courtroom, will also go to Top Mark Media. And then if I provide commentary, I'll bring in my Top Mark Media feed and do commentary over that. So that will allow some of the other creators that we work with to get a clean feed from court as well. So we'll do that. Let's see. Long discussion here. I wonder if anyone answered the invitation to be Boone's lawyer. I could check, actually. Let's see if there's any filing for an appearance. Sarah Boone, not a robot. There's her case. Nothing new. Correspondence received from judge. I think that's correspondence. No, nothing new since her help wanted letter. I am waiting anxiously. The Corey Richins trial. Oh, here we go. Sound's coming back up. It's coming up soon as well. We've got a hearing at the beginning of next month. Waiting for the court feedback on one of those hearings.
So I think you told us, Dr. Broder, that this policy of appeasement was designed by Ms. Benefield to basically placate Doug Benefield.
I think I would use the word strategy. That was her idea of trying to...
Yes, to placate him. In other words, to not set him off.
She knew that she wanted to reconcile, so she wanted to kind of, I think, feed into that so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
No. Did you acknowledge during the course of these evaluations that the signs were there that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
Whoa, what a response.
Well, let me ask you this. Did you consider that Ashley's position was that Doug was only interested in her and not in the child?
I certainly considered that, yes.
And that was Miss Benefield's position, was it not?
That his sole aim was to win her back, yes.
The abuse complaints, without giving me names, they were initiated by more than the same person, correct?
Correct.
In fact, there was
Objection, yourself.
The answer came in. Jury
Finish
heard
your
it.
question.
In fact, there was at least 3 different sources.
I'll overrule. Go ahead.
I believe there were 3, correct.
And 2 of those sources were professionals.
Sustained.
she expressed to you, did she not, real frustration with the system and its responsiveness to her situation?
Yes, she did. She was very forthright.
And she told you that with respect to taking matters into her own hands, it was going to be by virtue of her going to Maryland and petitioning the authorities there.
My concern was that she was going to impulsively abscond with the child and go to Maryland and, yes, establish residence separate and apart from Doug.
Okay, that she would have access to the authorities there, that they might be more responsive.
That was her hope, her goal, yes.
All right. Are you familiar in your practice with domestic violence?
Yes.
Have you treated it before?
I've assessed it and treated it on occasion, yes.
Did Douglas Benefield, from what you learned as a result of your involvement in this case, exhibit
Objection.
Couldn't finish your question.
Exhibit symptoms consistent with the domestic violence abuser?
Sustained.
Give me a minute, Your Honor.
Not sure why the state called him. He seems to have been more helpful witness for the defense than the state. He's a state's witness. No ME yet. Any minute now. Or possibly first thing tomorrow morning.
I do have one other area of inquiry, if the court will allow me.
That's a good question. Will the court allow it? Where are you trying to go, Mr. Taylor?
Did you find anything aggressive about Ashley Benefield?
No.
Did you find that Ashley Benefield had any impulse or was prone to angry outbursts?
Well, that's two different things, impulsivity and angry outbursts. I did not find her to be having angry outbursts, no.
You, in fact, concluded she was a good mother?
Yes, I observed her many times.
That's all. We'd like to keep Dr. Broder under subpoena.
Redirect.
You're familiar with mandatory reporting laws, right?
Yes, ma'am.
And what does that mean, mandatory reporter?
The mere suspicion of any kind of abuse towards a child or an elder, as well as domestic violence, needs to be reported.
So if someone goes to their child's pediatrician, or someone comes to you as a doctor and alleges abuse, what would you have to do?
I would have to report it.
Thank you. No further questions.
All right, doctor, at this point, we're done asking questions. However, as you've heard, you remain under subpoena. The rule of sequestration has been invoked in this case by the parties, so that means you cannot discuss your testimony or the questions asked of you with anyone else,
right,
including the attorneys.
Okay.
You can't talk with any other witnesses about what their testimony was or the questions asked of them. And to the extent there may be anything online about this case, you're not to review it or watch any of it. All right, so remain available in case you need to be recalled.
Just point of clarification, remain here today or be ready for tomorrow or what?
No, sir, you're released for now. Just if one of the parties reaches back out to you during this trial period, you will need to report back.
Understood. Very good. Thank you.
Fun fact, in Florida, anyone over the age of 18 is a mandatory reporter. Law requires everyone in the state to report suspected child abuse, neglect, or abandonment.
State calls Dr. Jason Quintel.
It's true.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Hello, sir.
Hi there.
My name is Judge White. I'm presiding over this case. As the deputy may have said, just make yourself comfortable in that chair.
Okay.
You'd end up wanting to be about 12 to 15 inches from the microphone. It adjusts up, down, left, right as you need.
Okay.
If you just speak in a loud, clear voice right into that microphone, it'll pick up everything.
Okay, great. Thank you.
Good afternoon.
Hi. Sorry, I spilled water.
He's trying to clean up. Made himself really comfortable. Just dumped
Please
water
state your
all over the
name.
witness chair.
Dr. Jason Quintel.
How do you spell your last name?
It's Quintal.
What is your profession?
I am a mental health counselor
How long have you been a mental health counselor?
since 1998.
And where's your office?
My office is in Lakewood Ranch, off of State Road 70.
And how long have you been there?
That location we moved into in 2018. Prior to that, we were on Lena Road from 2008 on, and then prior to that, 2006.
And at some point, did you become familiar with Doug and Ashley Benefield?
Yes.
Okay. And when was this?
That would have been in 2020.
And do you recall about when in 2020 that was?
They came in for their first visit as a couple's visit on 7/15/2020.
Okay. So we heard from Dr. Broder, he was talking about his goal was to do an evaluation. What was your goal with meeting with them? Was it an evaluation or something else?
No, I was referred by another therapist to do trauma resolution treatment for both Doug and Ashley.
Okay. And as part of that, did you meet with them together as well as separate, or how did that work?
I did. I met with them originally as a couple. We ended the treatment as a couple, and then there were individual sessions in between.
Okay. I won't hold you to this, but about how many times did you see them?
So I met with Doug twice individually, Ashley 5 times individually, both of them as a couple twice. There was a total of 4 hours for couples, 10.5 hours for Ashley, and 4.5 hours for Doug.
Okay. And at the first session, did it seem to you as though, let me back up. The first session, was it together?
Yes, it was.
Okay. And during that first session, did it seem as though they wanted to work things out?
During the first session, they talked about, yes, they wanted to work things out.
Okay. When they were together, did they indicate they wanted to get back together, like reunify?
The goal was for them to reunify and moving to Maryland.
Okay. When Ashley met with you by herself, did she still make that representation?
That they were moving to Maryland, yes.
Okay. And was there anything different about her representation?
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into specifics,
Sure.
but...
Ask the question. He's entitled to complete his answer.
Overruled.
Overruled.
So did she indicate she still wanted to reconcile with him when she was with you alone?
Overruled.
Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Okay. Did Ashley tell you that she and Doug were also seeing Dr. Broder?
They both mentioned that Dr. Broder was doing an evaluation, and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge, that didn't go her way. So I think there was definitely some discouragement with that.
Okay. And I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was taking for Dr. Broder's report?
Yeah, she thought that that was taking a very long time.
Okay. And did she express to you that she was worried about what his report would say, or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay. Did she, the last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day of the week that was? You might not, but.
Maybe Thursday, Friday? Okay. I can look if you need that.
No, that's okay.
Okay.
And about what time of day was it?
I believe that was a morning session, 10:30-ish.
Okay. Did they say Dr. Broder's report was done?
I don't recall them saying that the report was done. I know that they had been waiting on it, and it was supposed to determine specific things for how they move forward.
Okay. And did they indicate when they were going to court next?
I do not know that. I don't recall anything mentioned about when court was.
Did they indicate to you when they expected they were going to have access to that report? Excuse me.
No, I don't. There was not a when the report was going to be released. It was going to happen at some point.
Okay.
My understanding is that they still had plans to move to Maryland.
Okay. Thank you. I have no further questions.
Okay.
This is really sticking out to me that she feared Doug by this behavior. She talks more when he's there. She placates. When she's not there, she shares more.
Hi.
How are you?
There may
I'm
be
doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug.
Now the state's going to object.
In meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no
sustained.
Not going to get into
There it is.
Okay, without. Yeah. Oh, you have no idea. Without.
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out?
Oh my goodness. The judge is livid. Did you hear that?
Please don't begin your deliberations. You can use your phones, but don't talk with anybody outside of the jury.
He's about to come down on Mr. Taylor.
Don't do any research on the people, places, things, or
It's
legal
happening
topics you've
right
heard
here.
anything about.
Get out, run, jury. Witness, you can leave too.
Dr. Quintel, I'm going to excuse you to the hallway.
Okay. Take my stuff with me.
If you hear any screaming,
has been invoked.
I don't even know what that means.
That's unexpected.
Okay, sorry.
What that means, you can all have a seat.
Mr. Taylor said,
means,
"Oh, you don't even know."
You're not to discuss your testimony or the questions that have been asked of you if you're in the courtroom. It also means that you can't discuss other witnesses' testimony, and that's with anybody or the questions they were asked. That's with the attorneys, other parties, witnesses. It doesn't matter. You can't discuss anything that's gone on inside the courtroom when you've been in here. Also, that I understand this may be online, and you are not to watch anything online until you're released from your subpoena.
Then you're supposed to appear on Recovery Addict's channel.
Jury has been released from its duties.
Okay.
All right, so
Sounds great.
Thank you.
Thank you.
As he's leaving, what happened was the witness started sharing too much. We knew there was going to be an objection. He started going into what Doug had done previously with shooting the gun. The objection came in. It was sustained. The witness is like, sorry, I didn't realize. And Mr. Taylor said, oh, you have no idea, meaning that, oh, this whole court, this whole system has been like this. It's terrible. And the judge called it immediately, kicked the
Mr.
jury
Taylor,
out.
is there anything you'd like to share before I begin speaking?
Final words?
I'm about to catch a whooping. I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made. From the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break.
For the judge.
I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well.
That's a rough job.
For the criticism that comes with the job. However, those sorts of side comments are just, they're not appropriate, and I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right, so we'll take a 5-minute break and we'll be back.
Okay, so we're going to, let's see. We're going to pull in this last little recording and rewatch what just happened.
Shame on you, sir.
Wait. Backing up just a little bit. Here we go. Okay. Here we go. Let's bring it to camera 8 as they leave just for a minute. Box source 3 will be 8. Okay, here's our replay. Ready? So I'm in control of this now. This is a replay. So hold tight. We're going to listen very carefully to what happens here.
Maryland.
Okay. Thank you. I have no further questions.
Okay.
I think
cross.
So this is the start of the cross-examination. He wants to go into the same area that the state cut him off on.
Afternoon, Dr. Quintel.
Right?
Hi.
How are you?
I'm doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Sustained.
I'm not going to get into specifics.
Okay, without. Yeah. Oh, you have no idea.
That was it. Oh, you have no idea. The witness is like, sorry, I just stepped in. I didn't realize I wasn't supposed to say that. I mean, first question out of my mouth for you, the judge sustained an objection. What did I do wrong? His response, oh, you have no idea, was what was the bad part. So back up just a tiny bit. We're going to play it one more time.
Okay, without. Yeah. Oh, you have no idea.
Instantly.
Without.
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out?
Just like that. Just like that, the jury kicked out immediately. The judge was not having it. This, I believe, is the first comment we've had like this from this attorney in the trial. He's made some arguments. I mean, he's asked for this for a mistrial. Okay, he's been unhappy with the judge's ruling, but this is the first time he's made a comment like that, and the judge would have none of it. This is not a warning time, but I will say that the judge's reprimand was measured, was thoughtful, was in control. He's still taking a 5-minute break. He is taking a break for himself. Okay, and he gets up there and says, just so you know, yeah, that's going to be a soundbite for sure. I'm not sure which one. Oh, you have no idea? Or, I don't know. It was rude. It was rude to the court. And it was in the presence of the jury as well. I think that's what made it the worst. I think if that had happened in just a motions hearing with the judge or something like that, it would have been, it would have been okay. It would have been, put up with. But when he says, oh, you have no idea, in front of the judge, who has been very, very good, very consistent, making sure, protecting the defendant's rights, making sure she can hear on every single, sidebar, making sure that the jurors have pens. This guy is thorough, all the way thorough and consistent all the way through. And for him to make that disrespectful comment, that's pretty bad. That's the only other, the closest time we've had previously up to this was his creep comment, where outside the presence of the jury, outside the presence of the witness, talking about Tommy, Doug's cousin, talking about Tommy, Doug's cousin, he told to the judge, he did it because he's a creep. He's been creeping around all this. That got him not a sanction, but a telling off from the judge as well, saying that's not appropriate. You don't do that in court. Grab the whooping soundbite. We're gonna let's see. Let me back up and play that one again. Let's see, where was that? So witness gets up and leaves. Let's play. Go back to 8. Play that again. And the judge gives him the chance to answer first. Actually, what did my lawyer just do?
Is there anything you'd like to share before I begin speaking?
I think I'm about to catch a whooping.
Yes,
I'm not quite sure why, but...
Oh, don't say that.
Go ahead.
Yeah, he knows why. He knows why. That was terrible to say, I don't know why. I'm about to get a whooping, but I don't know why. Love the judge even more now. Absolutely, this judge is phenomenal. He literally took a spit in the eye right there from this defense attorney in front of the jury and took a deep breath and handled it appropriately. And now is going to take another deep breath and come back and act as if nothing happened going forward and not hold it against the defendant. This is what you look for in a judge. We've seen similar behavior like this out of Judge Carroll, although Judge Carroll gets a little more heated in his reprimand, and then he resets and comes back even. But really, just a wonderful judge. I don't agree with all of his rulings, but the way he does it feels fair, even though I think, oh, that should have come in or that shouldn't have come in. Love it. Absolutely love it. And I love that he called it out. I love that he called out and defend the witness when the attorney called him a creep. Not cool. Not cool. We are going to get that soundbite. It's going to be, I'm going to catch a whooping. I'm about to catch a whooping. who was foolish not to apologize. He had his chance. That was it. That if he had said, I shouldn't have made that comment, I shouldn't have let my frustration out verbally, I apologize, Your Honor. Boom. That would be much, much better than where he was right now. That's all he needed. And for him, he knows what he said. He knows what he said. Let's see. Laura says, Rob from Law and Lumber says he prefers a judge whose rulings are consistent, even if he disagrees. I agree with Rob. I do as well. I love it when a judge is thoughtful and consistent. It just has to be fair. They're a referee. They're calling balls and strikes. Okay. There's a set parameter where the ball has to go through for it to be called a strike. And if that window is always changing, nobody can win there, and you can't have a fair trial. But this is crazy. Similicious, you need to go back and watch Alec Baldwin's last day of trial as well. That was still my craziest day of court ever. Pick up after the 3 breaks in a row. They took a morning break, second break, and a lunch break all together, and then after that, and it just went crazy. But this one has been insane as well. I almost screamed here. It was the best. Doesn't look good, and maybe this is something that Jules had told us there during the break, that maybe Mr. Taylor sees that he's losing the jury, that he no longer has them. They don't believe him, that he's losing his chances to get his side out there, even if it's with state witnesses. But no apology. I wonder if there will be apology after the break, now that he's been informed what his crime was. And the judge even went so far as to say, to point out this was a subtle thing, but to point out the rules of professional conduct, which as an attorney he is honor bound to uphold by oath.
All right, let's round up Dr. Quintel. Get him back in here. As he's coming in, I want to remind both sides that the court has made a number of rulings over the last couple of months regarding the admissibility of certain evidence. Until those decisions and orders are revisited and changed, it is the responsibility of both sides not only to operate within those bounds, but also to advise their witnesses of the prior court orders and admonish them to stay within those bounds. All right,
okay.
Go ahead and bring in Dr. Quintel.
That's the other part. This doctor should have known not to bring that up. And yes, he's a state witness, but part of that is on defense, because defense should not have asked that question, knowing that it was getting to something they shouldn't bring up.
All right, welcome back, Doctor.
All right.
While you were outside, did anybody attempt to discuss the case with you or speak with you? Or did you speak with anyone at all about your testimony or the issues we talked about?
I did not speak with anyone. There was a reporter that came up to me, but I didn't engage with him or interact with him.
All right. Did that person ask you questions?
He said that he knew I couldn't talk, but here's a card. I said I don't want that.
Okay. All right. Anybody want to follow up questions about that? All right. Everybody says no. Let's bring in the
Who was the reporter?
You will bring the jury.
All right, y'all can have a seat. Welcome back, everybody. Anybody begin deliberations, talk or communicate with anyone outside the jury about anything we've talked about, or do any research?
No.
Everybody says no. All right, Mr. Taylor, you may resume your cross-examination.
Thank you. Doctor, did you, as a result of meeting with the two of them together and separately, did you reach any conclusions about the relationship?
Objection, relevance.
I think this would be allowed.
All right, you can approach.
I think the judge is thinking this one over. They're literally, this evaluation has been a key point in the trial, that they were both supposed to be evaluated, and this evaluation was done, and it was supposed to come out at a certain time. The state has suggested that this evaluation coming out and being made public in court was motive, or was the final straw that drove her to do what she did when she did it. I think because of the way the state has brought this out, where normally this would not be allowed, I think it should be. So I'd like to hear what the conclusion is. It's I say that is probably bad on the reporter as well. I don't believe we should interrupt court at all to, I love access. I love media access. I love to get the scoop. I love to hear the story. I've worked in the news media. I love that side of it. I like to be first to press. I can see all of that. But at the same time, the court process should be respected. And you shouldn't do anything during that court process, even for a news story, that would jeopardize the whole proceeding. I think that was the point for the witness. Let's see. Interesting look for the jury that the state doesn't want his ultimate thoughts stated, but the defense does. Yeah, this is interesting. It's their witness. It's their witness, and he had one job, right? He had one job. Well, he did marriage therapy for him, but it would have been the previous witness, though, that reached the report, right? That reached the conclusion with the report. I thought I was seeing something on my screen, but the lady in black, the prosecutor in black, does she have one strand of lighter hair? It seems to match perfectly the other prosecutor's hair, and I keep thinking that the other prosecutor's hair got mixed up on her head. It's like a highlight, I guess. Is it a highlight? Okay, it keeps catching my attention. There it is. Okay. It's very prevalent now. I have a similar thing with my goatee, only it's all of it. It's all turning white. It's the doctor's job to make the conclusion and the juror's job to decide if they accept it. It's called gray. It's called gray. Now we can't unsee it. She's not doesn't do a lot of the questioning. We haven't had her on camera a whole ton. This is an interesting question. Someone asked it earlier, and they said, sorry, I missed it. I'm coming in late. Has the state proved their case? Which is interesting. Gets us back to the point of this. The state does have to prove the case. If they don't prove it, I mean, look at it this way. It's weird because we're going into a case where the defense is saying, yes, we shot her. Yes, she shot him. Okay, that's a stipulation up front. Yep, she did it. It was her. She pulled the trigger. She was holding the gun. He died. That part we accept. And so that's not in our window for what we're supposed to decide. But in a way, it sort of is, because that's one of the elements that the state has to prove for their charge. I think they've proved it because they stipulated to it, but defense is still talking a lot, meaning he's probably trying to convince the judge. But we're getting the same body language from the prosecution as when they were losing previously. Lego my briefs. A big 14 months. Who loves you, RA? Lego does. That's who. Shout out to all my addicts. Love yous. 2. Lego my briefs. Thank you very much. Good to have you here. I've got to hear, in my head, I've got to hear from Ashley. I've got to hear her side of the story. If they say it was justified, maybe this witness will say, I mean, I don't think he's going to say that there was violence and, this marriage, shouldn't have happened. I doubt that it's going to come out that way. I don't think there's going to be any witness that comes out and says that. So we're going to have to hear it from her. Natural highlights. Looks good. Sorry, I have one job and I failed. Tater Tot, 13 months. Thank you very much. Hit the like button.
Did you make any inquiry, Doctor, about why Doug Benefield would want to stay in this relationship?
Judge, you have saying.
Oh.
That wasn't
you can answer.
Can you repeat the question, please?
Yeah.
Thank you.
He got thrown off by the objection.
Was there any observation by you
the state?
in response to why Doug Benefield would want to remain in this relationship with Ashley Benefield?
I questioned why both would want to stay in the relationship, but specifically to answer the question with Doug, I did bring that up in a session, that it seems like Ashley is saying very disparaging comments, and I'm not sure why and what you see in that ongoingly moving forward. I did bring that up to him.
In fact, you were perplexed by it, were you not?
I was confused, sure. It did, yeah.
Would it be a fair conclusion to say that he was hell-bent on staying with her?
I would say that he really wanted the relationship to work from everything that he told me.
Okay. We're going to have to recall you, so I'm done.
Redirect?
No.
All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free to go now, but one of the parties, one or both the parties, may actually call you back later. So all those instructions I gave you earlier still apply. Don't discuss your testimony with anyone, even the attorneys, any other witnesses. You can't watch anything that might be online or read any news.
No interest in anything of that anyway.
You're free to go now. Thank you, sir.
Have a good rest of your afternoon.
You too, sir.
Thank you.
Approach about scheduling.
Okay.
This is an approach about scheduling. We're not going to count as an objection. Apparently, we're going to see that witness again during the state or during the defense's case, which is going to begin tomorrow morning. Let's see where we are. Okay, so we've had count the witnesses with me: Alicia Byers, Barbara Russell, Dan Dickerman, Stephanie Murphy, Chris Gillum, Brian Moreland, Brad Broder, and Jason Quintal. We've had our 8 witnesses today. That's who they said we were going to have. It was 8. That was the 8th one. The last one is for tomorrow. We might have an early out this afternoon.
All right, members of the jury, the next witness may take quite a while. So instead of keeping you so late tonight, the attorneys and I have agreed it's probably better to just come back tomorrow morning and start fresh. So I'm going to let you go for now. If you would please say tomorrow time. Are you guys okay with the time?
Yes, sir.
All right. Let's again plan. What would we say today? 8:45, and get you up here and hopefully get started right about 9. So let's do the same thing tonight. Please remember, no discussion amongst yourselves. Talk about the weather, nothing else. Don't talk about the case with anyone outside of this jury. Don't do any research on people, places, things, or legal topics that you heard anything about.
Yes, sir.
Okay?
Judge.
We'll see you tomorrow morning.
We've got to have an ME. We've got to have an ME.
You too. Take care. All right. Thank you all. We'll see you tomorrow morning.
And like that, just like that, we're done. Until tomorrow morning.
Before we When you unsealed, we got the copies of I got the original order that you did, and then the clerk provided me the transcript and the emails. I think you said something, when you said transcript, was that the transcript you were referring to? Because the court reporter hasn't transcribed what happened.
Correct. I sealed, if you look at my order, I sealed her raw data, her notes, and any transcripts.
Okay, so I was going to ask her to do it, but I wanted to clarify before I did something wrong.
I have not requested it. I don't even know if one has been done, but it has been unsealed if there's one.
Thank you, sir.
Does your order, Your Honor, allow the clerk to give them a copy?
Yes. Everything's been unsealed.
We might be hearing about that first thing in the morning then. And now we're done. Everyone leaves the courtroom now. All right. What a day in court. What a day. We saw a lawyer get a whooping, an expected whooping, but doesn't know why. We had some very, very spicy exchanges between witnesses. A ton of objections. We're up to 131. Nearly, let's see, that was 93 objections today, if I did my math right. 93 objections today. We had 38 yesterday. Oh, my goodness. I don't know if Jules is going to be able to call in tonight. I will tell you that tonight at 7 p.m., Jules will be on Ada K's channel. Ada K is a friend of the channel. She is into true crime like we are, but she also is into sign language and translation for the hearing impaired. And so she runs a channel for that. Ada K is going to have Jules on to talk about this case and what happened in court. So if you want some more in-depth discussion, that is definitely something you want to put on your radar for tonight. We love what Ada K is doing, making the court accessible to people who require interpretation, sign language interpretation to follow along. And that is just great. So love that. Kathy, good to see you here. Kathy from Gossip, Rumor, and Innuendo. Wonderful, good friend as well. Ashley is out on bail, so she is free to go. She's not stuck in jail at the end of the day. I missed your client killed my client. Can you replay? Okay, I've got to get some sound clips. Phil from TYO Toys probably has a bunch of stuff from today. But your client killed my client came in today. We got the tell me about it, and I figure I'm about to get a whooping. All those comments today. We got some very, very spicy objections and argument back and forth. Some subtle lawyer jabs, sort of under the radar at each other, which were fun to watch and epic to witness. Let's see, what's the channel? Is anyone able to put Ada K's channel in chat? One of our mods. Oh, Phil on TYO Toys. Phil usually puts out, almost every day, he'll put out a highlights reel of things that happen in court, especially if it's a spicy day. And this is the sort of thing he lives for. So if he's got time to put one out, I imagine you're going to see some highlight clips from this trial there. He is TYO Toys on Twitter or on X. Let's see. Kathy, Gossip, Rumor, and Innuendo is also going to put out a morning. She does a very, very early morning little synopsis of the previous day in court and what's coming up, and those can be they'll hurt your tummy. You'll laugh a lot. A little bit irreverent. She'll say everything that's on her mind, which is great. Lawyer witness not so smiling, now that her feet are held to the fire. Yeah. So the soundbite, you have no idea. I think I can clear that one up. I think Jules is calling in. This is awesome. Hang on.
Call from
Jules.
Oh my God! Listen. Before we get into what happened in there, I just want to make something really clear to everybody. I was not the person that went up to the judge's chambers. That's number one, because everybody in court can take so,
you're cutting out a lot, Jules.
Okay, I was not the person that went to the judge's chambers. Okay, I don't know who it was. I was with other reporters at the time that took place, so it wasn't me. The other thing I want to say is I'm not the one that approached that witness in the hall either. I do know who it was. I'm not going to say who it was, but it wasn't me. But God.
Yeah, wait till they're released. Wait till they're released and then meet them in the hall. Don't, under oath. Yeah. Dinner break, that was so wrong. Okay, so Mr. Taylor, we just witnessed a 72-year-old lawyer get bent over the judge's knee and get a sound paddling. And I think he deserved it. Oh, my goodness.
Yes. And, okay, we all know that Ashley Benefield has been very non-responsive throughout the whole trial, as she should. I'm sure she was instructed to be that way, as she should, okay? However, I can tell you this. She's not happy right now.
She's not happy with her lawyer.
Happened, no, she's not. It was very clear. She turned around and she looked, to the, I don't know if it was caught on camera or not. She turned around and looked to the paralegal and, the big guy that sits behind her.
Mr. O'Keefe.
Yeah. The look on her face, oh my God. If there was any way to get a picture of that, it was bad. It was bad. She clearly was upset, and she was upset with her own attorney.
And rightfully so. I mean, it was an inappropriate comment. It was inappropriate and got the judge's ire. It was in front of the jury, so the jury knows. I mean, they can see what happened, what led to the judge kicking them out, and they know that lawyer stepped in it, and the judge is upset with him.
Well, the two women that sit in the front row, the ones that have been very not, I don't know what word to use, non-committal or whatever, until this afternoon. Then it's like their whole body language has changed because they were not, like with Gillum, they were nodding in agreement with him. They've been nodding in agreement the whole time. When that incident took place, the one woman, if her eyebrows could have gotten any further up to her hairline,
should have scalped herself if they went much higher.
Yeah, she was like, it was like, what just happened? And all she kept doing was darting her head back and forth between the judge and Taylor, back and forth. And when the judge said, jury go out, bye, they were like, they were perplexed. They knew something very, very wrong took place, but they also appeared confused.
I would say that Mr. Taylor did a poor job today. And part of it is because the witnesses just didn't provide the answers that he was seeking. But in the cross-examination, we had one witness, and that was let me give you his name, just 1 second. Let's see, Dr. Broder was good for the defense, I think.
I thought 50-50 on him. I thought it could go for either side.
He definitely wasn't leaning on the state's side, but that was pretty much the best one he had today. I mean, it got spicy with Stephanie Murphy, but
yeah. But this last one, I think, maybe I'm reading too much into it, but I think if Taylor was allowed to ask those questions that he wanted to ask, I think he would have really made a good defense witness. Now, he is going to be called back by the defense. Yeah. So I don't know, does it change things? Will he be allowed? Will that door
It's possible because a lot of things can happen between now and then that can change the judge's ruling on whether something's admissible. The foundation being laid, a question being asked by the state, a witness saying certain thing on the stand. Lots of things can happen. So something that he couldn't go into initially, he may be able to later on, and that'll be interesting to see if that's allowed. But the state will have to step in it for that to happen. The judge has been very consistent. And honestly, I love this judge. It's Judge White, right?
I like, yes, yes, Matthew White. I like him as well, and that little outburst he had, and then the stepping off the stand was very reminiscent for me of Judge Carroll.
Yes, from the Maya trial. That's what I was thinking watching that happen. Jules, we are super excited. I don't mean to cut you off. I know you've got some more things to talk about. I don't want to get all the good stuff from you and have people miss out on tonight's appearance where you will be on with Ada K on her channel. So,
Thank you for plugging Ada. Thank you.
As much as I would like to hear all the details, I think it's only fair to let you have some good stuff that you can share first on her channel, which we love. She's growing rapidly. She's a great individual. She's put in a lot of effort and has just a unique talent that she brings to this whole community that isn't represented anywhere else as well. So I do encourage you to go check out the Ada K's channel tonight. And what time is that going to be? 7 p.m. Eastern?
7:30 Eastern Standard Time.
Okay, and we did put her link out in chat for her channel. It's this one right here, Ada K Juror. So if you search for just this last part right here, well, the part that I don't have highlighted on YouTube at Ada K Juror, that's her quick link to her YouTube channel. It can be a little difficult to find. It's sometimes harder with newer channels, and sometimes hers can be hard to find. So look for that at Ada K Juror, and that'll get you there for sure.
Oh yeah, but yeah, because I'm going to be spilling.
Wonderful, and I look forward to that. Jules, thank you so much. Okay. Drive safely tonight. Are you going to be back in court tomorrow?
I will, and I'm going to dress more appropriately because I did have to move because I couldn't handle the air blowing down on me any longer. So no open-toe shoes. I will be in tennis shoes and socks. I will be in a sweatshirt. I'm bringing a blanket. Seriously.
I'm thinking a Carhartt overalls and a heavy down jacket might be appropriate.
Don't laugh, there was a woman in court with a down jacket on.
It's so cold there. It's either too hot outside or too cold inside.
Yeah, I will talk to you tomorrow at first break.
Sounds great. Jules, thank you so much. Appreciate all you do.
You're welcome. Have a great time.
Yep.
All right.
Bye.
Bye-bye.
That was the notorious Jules. If you guys followed the Maya trial, she was also our eyes and ears in the courtroom there. We rewarded her by making a custom Recovery Addict jacket with her own emblem on the jacket, a hoodie, a zipper hoodie. Maybe she can wear that to court. I'm not sure if it would be allowed, but we really appreciate what she's done for the channel and what she does as a court watcher for us. Appreciate that. Look forward to her spilling a little bit more details tonight on Ada K's channel. We're excited for what they're doing over there, and so I wanted to save some good stuff for that channel as well, as much as I want to hear everything here as well. But with that being said, we are done for the day. What brand is that AC? Asking for Karen Reed Judge. It's not a fan. I can tell you it's not a fan. It's a good one, whatever it is. I think we're done for today. Quick recap, very, very quick recap for those that missed. This is day 2 of the Ashley Benefield murder trial. She's accused of shooting and killing her husband, Doug. This was background on the relationship. It sort of started when they met at a political function. After 13 days of probably nonstop texting, they got married. Yes, I said 13 days. They had a whirlwind courtship, got married. She paid to reverse his vasectomy, so they unsnipped the snip, and she got pregnant about a month later. Shortly after she got pregnant, she started getting morning sick. She says, I want to be with my mom down in Florida. So she sort of moved down to mom, and they never got back together. At least not permanently. So she stayed down there. The baby was born. She didn't even tell him that the baby was born. They found out through court record filings, through his attorney. He had to file for, they're arguing things out. He's trying to work this out. She does not want to work it out. They had a business venture together that was in South Carolina that failed very soon after they started it. Just a couple months. A lot of ballerinas on the payroll that never got paid. And things just fell apart very quickly, almost as fast as they came together early on. But it ended up with her trying to move some stuff out of her house. He was there helping, and at times they did sort of get together and do things. Her mom took Emerson, their daughter they had together, a 2-year-old, to the park. While she was gone at the park and they're moving boxes, some sort of altercation occurred. And it ended with Ashley shooting and killing Doug. She then ran to the neighbor's house, knocked on the door, beat on the door, came in. The good neighbor took her in, called 911. The police came, arrested Ashley, as happens if you shoot someone, even in self-defense. You will get arrested. That's how it works. And as at least she alleged it was self-defense. And then they released her. She wasn't really arrested again and charged until like a couple months later. And after they did a lot of investigation. But a lot of crazy stuff here. It's bizarre. It's a little bit wild. But are we sure an altercation occurred? Only because there was a body at the end. That's all we know. The entirety of the altercation might be him getting shot. There might have been nothing that led up to it. It could have been a planned murder. We just don't know. What we do know, what we heard in testimony today, is a couple things that stood out. First of all, that Ashley Benefield, at least to the professionals that saw her in a marriage counseling and psychological evaluation type setting, felt that she was different around him, like she was placating. She would do what he wanted around him, and when she was on her own, she could share more. That, to me, shows a sign of some sort of fear. Either she was really good at doing that and faking it, but it shows that there was some sort of problem in the relationship. The fact that we have a bullet hole in the roof that apparently Doug caused, a fist hole in the wall that apparently he caused, a dog that got punched and knocked unconscious that he did, that are also indicators that this marriage wasn't all roses. That being said, we don't have a lot of evidence to show that she was really in fear for her life. We don't know what happened there in the house, and if she hasn't talked to anybody about it, because she literally lawyered up before the police were called. She hasn't told her mom. She hasn't told her therapist, who she lived with for 8 months. Just nobody knows. We haven't heard this story. She didn't even take the stand in her own self-defense hearing. So crazy stuff. We've had 2 days of witnesses. 1, 2, 3. Let's see, 4, 5, 6, 7, 8. So 16 witnesses total so far. At least 1, possibly 3 more tomorrow from the state. I'd love it if the ME is in there, because we have not heard from the ME, and I think we need to hear that. That will help us understand a little bit about positioning of the body and how the shots could have occurred. I think that's important to understand what happened at the house. We have heard also from professionals that Doug seemed to have an interest in keeping the relationship together, possibly an unhealthy interest, but seemed, the lawyer used the term hellbent, but he seemed driven to maintain the relationship and keep it in place, where Ashley not so much. And the last witness, Dr. Quintel, said, I actually asked both of them, why are you guys trying to stay in this? Why are you so interested in staying in this? This is a failed relationship by what he could observe. Some kind of fear or manipulation. She got him to do what she wanted him to do. I think she could. And this is funny because, Virginia, I say that she showed signs of fear of him, but at the same time, I think she knew she could control him by giving him hope that the relationship could be salvaged. And so I think there was possibly even manipulation on both sides. This could have been unhealthy on many different levels. Let's see. Anything else about that? So much happened. The mystery person contacting the judge flew under the radar. Yes. After lunch, judge comes out and says, oh, by the way, somebody came to court, told the deputy, I'm a news reporter. I've got something to tell the judge about this case. I've got evidence. Deputy tells the judge tells the deputy, tell him, bring it to court, stand in court. We'll start early. You can tell us all in open court. And they disappeared. Apparently they don't want to be in open court. I wonder if something will develop here. We've only got a couple days, so we'll see what happens. I doubt any reporter is going to stand in open court and testify about something, especially if it's something they received through their work. It would have to be like personal knowledge. I don't know. Why would they come in at... it seems strange, just bizarre. Yes, she got him to get the vasectomy. She paid for it on the credit card. Once she got pregnant, she went to Florida, had the baby in Florida, kept the baby in Florida until a court basically ordered that there was going to be some joint parenting time. And then they sort of got back together, or at least worked together. Even though they didn't live together, they sort of made it work somehow. They were barely married before she left. The whole situation is bizarre. Evidence so far is conflicting. Conflicting evidence, what does that leave us with? Not guilty, right? If you expect a happy ever after marriage after 13 days, please run the opposite way. I know some that work. We've got people in chat who have had shorter courtships. Sometimes you just know. In this case, I would say they didn't, or there might have been some other driving factor. He was basically retired Navy, 54 years old. She was 24, 30-year difference between the two. She seemed to have a lot of interest in him supporting her financial endeavors early on. That might have been a factor. How long from marriage to baby? I think there were a couple of years. Was it 3 years they were married? I don't remember. All right. Yeah, so a little bit yes on the money. My courthouse ship has lasted 17 months. That's why it's orange. It looks great, Adam. Thank you very much. Let's see. We're going to wrap things up here today and let you guys have plenty of time. I do encourage you to listen to some of the great commentators who are also following and recapping this story. I know Peter Tragos, the lawyer down there in Florida. This is his neck of the woods, not far from anyway. So he's probably going to have some great insight into the legal workings that were happening in the courtroom. And I'm sure he's going to have something to say about that reprimand as well. So that's going to be fantastic. Ada Kay is going to have Jules on, who was there in the courtroom again today. She's going to give some more details about what she saw and what they thought about during the court today. We've got a bundle of other lawyers who are going to give updates as well. So please peruse the options and listen appropriately. We'll be back tomorrow morning at I think we're going to start at 8:30, if that's all right. Would like to say once again thank you to the new friends we found. Looks like we have a few more who have come through the door. Welcome. For all those who are new to the channel, welcome. We really do appreciate you being here. Please do stay. Please come back. We have a lot of fun here. So tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again tomorrow morning at 8:30 in the morning. It's early. I'm going to take a nap. I might go mow my lawn now that I fixed my lawnmower. I might go mow my lawn if I can find some more bug spray because my can's empty. All right. I think that's all. I think we're done. Catch you guys tomorrow. First person in chat, as always, wins the internet. That could be you. Just click the subscribe button, then ring the bell to be notified when we go live. As soon as you get that notification, be the first person to chat. And you too could be a winner. And you could have a fancy little certificate.
Shame on you, sir.
Yes, shame on me. Fancy certificate commemorating your win, internet ownership. Weatherwatch says we can put up Halloween decorations. We're going to have to talk about that tomorrow on the podcast. Also on this channel, 8 p.m., Weatherwatch and I will have that podcast. Don't miss that either. I think that's it. I need to update my image.
If they didn't, I would lose my mind.
I cut that one off last time. Sorry about that. We're going to break right now. You guys have a good one. We'll see you. Bye.